Okay, on behalf of the School Improvement and Turnaround Committee, I think that's the name of it, I'd like to call this meeting to order. Can we have a roll call, please?
Ms. Beebe?
Thank you.
Ms. Beebe?
Present.
Ms. Beebe is present. Mr. Bennett?
Here.
Mr. Bennett is present. Ms. Bophy?
Here.
Ms. Bophy is present. Ms. Bradford?
Here.
Ms. Bradford is present. Ms. Dastug?
Here.
Ms. Dastug is present. Mr. Garvey?
Here.
Mr. Garvey is present. Mr. Gio?
Here.
Mr. Gio is present. Ms. Hill?
Present.
Ms. Hill is present. Mr. Lee?
Here.
Mr. Lee is present. Ms. Orange Jones?
Present.
Ms. Orange Jones is present. Mr. Romer?
Here.
Mr. Romer is present. You have a quorum.
Okay, first item.
Your consent agenda is actually ready for approval, adding items 2.1, 2.3, 2.4, 3.1, and 4.3. These are your start items for our board members.
Ms. Davis,
Yes, ma'am.
I'd like to pull 2.1 for discussion, please.
Yes. Let's pull that, and Ms. Beebe, can I ask you to pull 2.4 also?
Yes.
Thank you.
2.1 and 2.4.
Mr. Chairman, I'll make a motion to approve the agenda with exception of items 2.1 and 2.4.
I'll second.
Ms. Dastug and Mr. Gio. Do we have any objections to that motion? Hearing none, motion carries. Next item.
So your first item will be 2.1 on page 1. Consideration of the extension of the charters for types 2, 4, and 5 charter schools in the 3rd year of operation, and the renewal of charters for charter schools in the 5th year of operation, or those in the final of their charter. Recommendation is to approve.
Do we have a motion to approve? Or
Oh, excuse me, motion is to delete. I'm sorry.
delete? We have
I
a
apologize.
motion to delete.
I'll move to delete.
Ms. Bradford and
Second.
Mr. Romer. Ms. Beebe, did you have any questions?
Well, yes, I would like some clarification. So if the recommendation is to delete, in reading the supporting documentation, there was are we moving away from both the January and the June deadline? We're just deleting that policy altogether or procedure?
It seemed, I don't know, I mean, somebody else may answer better than I. It seemed to me that the law, the way it was written, the regulation, the way it was written, we could already do, in effect, what we wanted to do here. So we didn't need to keep considering this item, but somebody smarter than me can probably say
And the
better.
department will bring those as needed.
Okay.
So it's just not going to be a standing item on the agenda.
So, will I be in order to address, I think it was the Vernon, and I don't know if I'm pronouncing it correctly, from the Recovery School District. I was just curious as the status. I know at one point they came, I think it was in January, they came before the BESE to request that they be allowed to return to the Orleans Parish School Board. So, what is the status of those procedural guidelines in the event that a school would want to leave the Recovery School District to go back to the Orleans Parish School?
I think that after that meeting, what we had said is that the department was going to work with the Orleans Parish School Board on Orleans Parish School Board developing a plan for return per the regulation, for return of schools per the regulation, because the regulations require that the district have a plan for return. We've sat down, we've worked with them on it. It's not finished yet. I think it's a long process, and when that process is complete, we'll bring it back to the board. And the board does need to approve that plan. But I would say that it does.
Okay.
It needs to approve the Orleans Parish School Board's plan. But I would say that right now, frankly, I think this falls upon the Orleans Parish School Board, which is well aware that if Berman is to return, which we as a department would have no objection to, Orleans Parish would have to have a plan that they're ready to implement themselves, and they have yet to produce such a plan.
Well, I think I'm going to go a step further. I think it's unfair to this group and others, and that's why I would ask you, as our superintendent, to maybe, call someone with the Orleans Parish School Board. I know it's their responsibility, but in fairness to those groups, I think we need to get the ball rolling, because we're in June, and if this is to be approved by January, then we need to take care of business.
Noted. Thank you.
I have a question. and I guess this is for Superintendent White. I was working closely with that group, and to my understanding, when I spoke with the Orleans School Board, the representative, they said that there's nothing in law stating that in order for a school to return to their local district, that they have to have a plan. So is there some policies in law, because according to them, there wasn't any law particularly in place stating that when a school have met the standards of BESE requirements, that they can return to their local school district. And according to the New Orleans School Board, they said there wasn't no law and they weren't aware. So I'm just trying to make sure I have some clarity there. Can you clarify or help me to understand that?
Sure.
Or if it is a policy, where?
I mean, that might explain why when we called them to get the ball rolling, they haven't responded as much. It is in the policy, not in the statute, that says that there will be a process where they will produce a model for return, and that model they will articulate. It will be passed by this board, and so on.
If I may add some color to that, if I'm not out of order,
Mr. Romer?
Thank you for recognizing me. One of the reasons and this was prior to your term, one of the reasons we articulated that need was there were many schools that expressed at some point they would want to return, but their hesitation was they needed to be certain what the terms were that they would be going back to Orleans Parish School Board under. And so we required that the Orleans Parish School Board articulate, what is that process, how would this school be treated, et cetera. So that's why we did it, and it is in policy, not in statute.
Mr. Chairman?
Ms. Dastu?
I'm going to have a question for the superintendent also. Just refresh my memory. If you go back to the charter school contract, who can? I think that really is the bigger question here. I understand the effort in trying to get the groups together and develop a process and sort of set the stage for an ultimate transition. But in fact, it is the board. Am I correct? That would actually notify this board on whether it wishes to return to Orleans Parish. Is that correct?
That's correct. It's the board of the charter school that would notify. Then the Orleans Parish Board would have to have a plan for return, and this board would approve the plan for return as well as the charter board's petition.
Okay. So it seems to me that the effort around with Orleans working on this plan to be in a position to receive and to continue the success of that school is that clearly delineated in the contract, or was that just an effort to be able to get to the next step of transition?
And maybe I just want to maybe make sure I understand what you're asking.
I think the question, Ms. Hill, is that the contract doesn't require that Orleans Parish have a plan to receive, only that the school board notify BESE of that it's met the criteria and it chooses to return.
Right.
So it seems like we have two different efforts here going.
Yeah, I think, I mean, this is a complex situation, but I think that probably Ms. Hill, and I'm extrapolating, but I think probably Ms. Hill's comments from the lawyer reflect the distinction between what's in the statute, what's in the policy, and what reading thus a lawyer or someone else may choose to apply given one's interest and vantage point. There has been some discussion that the board saying we have a return policy, and I know that when Superintendent Pasternak was here, this was an issue of a lot of discussion, isn't a valid thing because the law says that it's to return after 5 years, or that's those people's readings. Clearly, the law gives BESE the authority, and the law and BESE has chosen to create a policy that provides for a return model that must be approved. And I think what probably my experience in New Orleans led me to think is that there are some people say there shouldn't be that policy. Well, there is, and we can't just ignore it, and I think probably some people are choosing to just ignore it.
Okay, thank you.
Mr. Garvey, one additional
Ms. Beebe.
comment. My recollection of the discussion by the Berman group was the board, the charter board, was reluctant for them to return to the Orleans Parish School Board. So in the event that the board has to give their blessing or seal of approval, I think that we will have some conflict there. So once again, I'm asking you, Superintendent White, to start the conversations, because looking at the time frame that we have remaining, we need to make sure that all entities understand their role.
Fair point. I would say for the board's context on this one, I know it's going to continue to come up. We're trying to get the ball rolling with parties, neither of whom necessarily want the ball to be rolling. So, in other words, I'm not sure that Orleans Parish necessarily wants the schools back, and I'm not sure necessarily that Algiers Charter School Association wants the schools to go back. So we can do everything we can to get the ball rolling, but in spite of the people who come to the table to petition, that doesn't mean that those people's views are, reflected by the people who actually govern those entities. And so the ball is rolling, but Orleans Parish has to step up, and Algiers Charter School Association would have to step up, and I'm not sure that that's going to happen. That's their decision.
I hate to beat this issue to death, Mr. Chairman,
Ms.
but it is not
Astu.
our role, it is not our job to get the ball rolling on this. It is our job to make a decision, to develop processes, and then make a decision that I think aligns with law, policy, and the contract. So I disagree respectfully, Ms. DB, that it's not our role to push the ball. That is really between Algiers Charter School Association and Orleans Parish School Board. That's my opinion only.
And I respect your opinion, and I agree to disagree. And again, Superintendent White is the person that we charge with carrying out expectations and so forth. And I think we need to be concerned or cognizant of public perception and a willingness to work with all entities, and that's all I'm suggesting. I don't want to face these people again in January and hear the criticism that the ball was dropped or nothing happened. I mean, we have to be respectful of these people. Thank you.
Okay, we have a motion on the floor, I believe.
Yes, sir.
Do we have any objections to the motion? Hearing none, motion carries. Next item.
The next item is item 2.2 on page 2, consideration of a report on types 2, 4, and 5 charter contracts and requests for amendments. The department recommendation is to approve.
So moved.
Mr. Estu, we have a second.
Second.
Mr. Gio, do we have any questions? Do we have any objections to the motion? Hearing none, motion carries. Next item.
Next item is item 2.4, which was requested to be pulled, page 5, consideration of a report on the status of Lycée Français de la Nouvelle-Orléans spring enrollment process. The department recommendation is to receive.
I'll move to receive.
Mr. Romer, we
I'll
have a
second.
second. We have a second. Ms. Hill, do we have any questions from BESE members? Okay, I had a question. Do we have someone from the department that can speak to this? And I'd like to ask the BESE members if they remember this issue the way I do. I thought we were going to get a report. I thought there was a concern that this school was going to selectively seek enrollment from particular groups of students instead of really opening the enrollment on a parish-wide or district-wide non-discriminatory basis. And I thought we were going to get a report that would give us numbers showing that, in fact, it was a fair process. I don't remember if those numbers were going to show that there was a equal representation of low-income families and high-income families and stuff like that. But that's the way I remember it. Does anybody else remember that too?
No one remembers anything the way you do.
Well, okay. Does anybody
Mr.
remember
Garvey,
anything?
you and I had conversations about this, and I think when I read this executive summary, I felt like they had addressed the lottery process. I think that the main issue was whether or not they would be receiving a disproportionate number of students who had prior French experience, and therefore perhaps you would have families coming from a previous school, that was the big concern. I don't remember it getting into the socioeconomic kind of measures. I don't remember. I didn't have that conversation. So I was satisfied with this report.
Do we have any numbers on the low-income, high-income ratio of students? Free and reduced lunch students, things like that?
Hi, Raphael Gang from the department. We had multiple conversations with LICE following the material amendment that was approved by BESE in April. They committed to doing an open enrollment process, and they followed through on that. We monitored them closely through that process. In terms of at-risk percentages, approximately 1/3 of the students that were admitted through the second grade process were deemed at risk. And then the school's at-risk population has grown significantly from its first year in terms of our estimates for what we expect it to look like in the fall.
Okay, and do you feel that they properly publicized this enrollment process?
Yes, and we had multiple conversations with them where they indicated to us that they were doing outreach in specific targeted communities that were, high need communities and with specific demographics that would not have previous French experience. And they told us specifically what they did, and we didn't include the specifics in the executive summary, but we're happy to talk with you more about that.
Well, you give me the kind of information I was looking for right there.
Great.
Okay, thank you very much. Okay, we have a motion on the floor. Do we have any objections to the motion? Hearing none, motion carries. Next item.
Next item is item 4.1 on page 17, consideration of the creation of public benefit corporations for the completion of the school facilities master plan. The department recommendation is to authorize.
Okay, do we have a motion?
I'll move to authorize.
Ms. Astute?
And I'd like to speak to this.
Okay, Ms. Bradford, second. Ms. Astute?
This is really a comment and request of the superintendent. The board received a letter of resignation from Mr. Paul Flowers, from I think it was the School Facilities Master Plan Committee. I believe that he donated a tremendous amount of time and expertise to that effort, and I was going to just suggest that it might be appropriate if the board and the department send a letter of acknowledgement and thanks to him. So if you'd like that to come out of our office, but I'd like you to share in that letter.
Absolutely. I couldn't agree more. I would say that and New Orleans and the state really do owe Paul Flowers a debt of tremendous gratitude. For Paul, we did do a kind of thank you ceremony at which he was given a golden shovel of some variation thereof. I'm guessing he might have already had one of those, but we will certainly at the state level will send a letter, because I agree that Paul Flowers deserves that level of thank you. So we'll do that.
Go so far as making a Paul Flowers Day in New Orleans or something. But no, he did. I don't know that we'd be where we are today without his efforts.
Absolutely not.
Mr. Astute, thank you for bringing that up, because I couldn't agree more. Ms. Beebe?
Yes, I was just wondering if someone could just offer additional clarification, if nothing more for my benefit, so that I would truly understand this item.
Yes, we have someone from the department. Do you have any particular questions you can ask them to answer?
Well, I know that it deals with the school facilities master plan and the limited liability corporations, but just if you could add some information to help me understand what you're asking here.
Sure. Annie Cambria from the Recovery School District. So in the school facilities master plan that was approved, that you guys approved in October of last year, part of the revenue sources were tax credits. In order to be able to take advantage of tax credits, we have to create corporations, which are called public benefit corporations. This authority was granted to us in the Public Facilities Finance Act, and so we'll be setting up these corporations in conjunction with the Orleans Parish School Board to help us take advantage of those tax credits, so we can basically get additional revenue into the school facilities master plan.
And within that process, what is the board? What is the board's responsibility as far as oversight of these separate corporations? This particular board, how is that going to? Who do they report to?
So the board would actually report. The governing board will report to the Recovery School District and the Orleans Parish School Board. So they will be governed equal, depending on, they haven't been set up, so depending on how that governing board is set up, the plan is to have them set up so that they will report to the Recovery School District. And then also, before any of these financial closings happen, they'll actually have to go before the State Bond Commission, and so there will be checks and balances there to make sure that additional revenue is being brought to the table, to make sure that the fees aren't too high, to make sure that this is really a good use of public dollars.
Mr. Romer?
So technically, the real estate is transferred to this new public authority, is that correct?
It will either be transferred or leased.
Or leased? And will these new entities have operating agreements?
Yes.
Is it called for those operating agreements to be reviewed by this board?
By BESE? Not currently.
Is there an opinion to whether it should be reviewed by this board? I have no...
Mr. Romer, do you have an opinion?
Well, I have concern. I have a concern, legitimate concern, I think, which is...
Me too.
I don't have an issue with this mechanism. Obviously, if this mechanism is required to get the tax credits, then it's probably a mechanism we should utilize. I do have concern about the ultimate real estate being transferred to another entity, and we not necessarily have review of the operating agreement of that new entity. I don't want to micromanage from up here, but if that gives me some concern. As who would be writing that operating agreement and who has to approve that operating agreement.
So, Mr. Roma, what we could do is then maybe work out to the board's satisfaction that we can maybe have a report or just a timely report on those transactions. I think the biggest thing for us then that we look at the scope of this and the magnitude is this is going to ensure that 100% of the children in the city of New Orleans that have been funded through the master plan, this is a key part of it to see that we're able to follow through on those new renovated or refurbished buildings. So as far as it would give the board comfort, with that technical nature of it, we'd be more than happy to do something that would satisfy the board. But again, to not slow down with so many different steps that it will hamper what we're trying to do as far as being very timely, yet responsible in rebuilding these schools.
Mr. Garvey?
So if it could be of just a reporting nature to give us a level of comfort, we'd be more than happy to do that.
Mr. Guillaume?
Mr. Delbert, who ultimately will have the responsibility for the maintenance of these facilities? Will it be this new corporation?
No, it still will be between the governance of the RSD as well as Orleans Parish School Board. And this is one of those areas where we're redefining, or rather defining, what governance around facilities is going to look like in the city of New Orleans. And so we've been working very closely with OPSB on this, also through the Blue Ribbon Commission. And so, these are one of those areas, enrollment's another area, where we feel as though, what's government's role in the long-standing capacity to keep those things moving us in a positive direction. So ultimately, it's still going to be between OPSB and the RSD.
I have a question, Mr. Delbard. These are LLCs or corporations, if I read the documents correctly. Who's going to own those corporations?
They'll be owned by the Recovery School District and the Orleans Parish School Board.
Well, in what percentages then? If it's going to be owned by two, is it 50-50 completely?
It'll be 50-50.
Who owns the buildings now?
The Orleans Parish School Board. Sorry.
Right, so they'll be giving up half of their ownership if they give us 50% ownership in these corporations. I don't know, I guess that's a question.
Yeah. That's correct, but they're fine with the logistics of how it would have to work in order to actualize the tax credits, to be quite honest. And so for whatever mechanisms we need to put in place to satisfy, to create the LLCs, it's to make certain that we're able to actualize and be able to receive the tax credits. But ultimately, they still own the land. But for the purposes of this, using that, we have the authority and manage certain sites that we're working that out with them.
And it really will be a lease structure. So it'll be a long-term lease. So when it says transfer, it will be a long-term lease structure.
And these corporations will own those leases, those long-term leases?
Correct.
Yes.
I just have a question.
This board, Ms. Hill?
I have a question. I'm just trying to understand, because I had a situation at a school with the RSD, and half of the school was insured, and the other half was not insured. However, the EBR school board was responsible for the school, but the RSD was leasing out the school. So I'm just trying to get a clear understanding how we're going to have accountability and oversight to make sure that situations like this doesn't happen when we try to contract out with another company. Could you help me understand? I'm just trying to get a clear understanding.
Well, and I'm not exactly certain of the example you're giving, but when we talk about facilities, so we work with whatever district, whether it's EBR, OPSB, where we have facilities. There's certain operation things where the district is responsible, but we'll take our percentage of like maintenance and the work that we have to do. And so there's just agreements between our operations staff and theirs on school facility maintenance. And so we hadn't really had any issues as far as like understanding who's responsible for what. Sometimes when it comes to capital repairs, there have been some misunderstandings as far as, if to repair an HVAC system. And in some schools, they may not even had an HVAC system before the RSD took the school. And then to ask the RSD to put in an HVAC system where we don't feel like that's fair and have some understandings with district as to like what's our actual responsibility. And so, we continue to have open dialogues, but if there's some specific situation that you would like for us to look into closer to make sure that everyone understands their roles, we'd be happy to.
Mr. Chairman, I'm sorry.
I thought Mr. Gill was, okay. Superintendent White?
Thank you. Would it be helpful if the Recovery School District staff work with BESE staff to propose a process for review and report to the board on these issues as a regular item in the RSD capital plan reports at meetings?
I guess we look to the BESE members. Is that what y'all are looking for?
I mean, I think that would be a good idea for us to come together and to come up with the RSD to work closely with us, so at least we can know, as far as the accountability and oversight in the governing process.
Mr. Romer, are you looking for any particular items to be in that report that you'd like to mention for the minutes?
I think there ought to be some reference to our ability to review within the operating agreement. I tell you what I'd really like to do. I'd like to defer this item until tomorrow. And I don't want to make it overly cumbersome. So I want to make sure we don't come up here ad hoc with some policy that it's overly cumbersome and really doesn't meet what we want to do. We want to allow you to do this, okay? We want to make sure this works as it needs to be done timely. I think we need to spend a little time offline rather than to try to hash out some details here that we may get incorrect. I'd like to defer this item until the full board meeting to make sure we get it right, and we'll get it right at the board meeting.
Is that a motion?
If before you, I guess, proceed with that, I would ask to allow Superintendent Smith from OPSB to just chime in, because they're offering the same resolution to their board. So.
Okay, and I noted that. Was it tomorrow that you're doing
That's in tomorrow's meeting, yes.
Okay.
And Stan Smith, actually, still Chief Financial Officer of the Orleans Parish School Board, soon to be interim superintendent. Our board is acting on this same resolution tomorrow. It's been in tandem with staff of the RSD that we have crafted this solution to try to maximize or try to take advantage of the tax credits, and we're certainly, from the OPSB standpoint, willing to work through any issues that you may have. We realize this is sort of an unusual situation. We think that by doing it through a ground lease to the ultimate LLC and things of that nature, that does not destroy OPSB's ownership, ultimate ownership in the property, and that and we have our attorneys certainly taking a close look at it and trying to make sure that the appropriate.
And I tend to agree. I mean, you're probably correct. Does it cause you significant problems if we delay it until tomorrow to make sure that we're absolutely certain on the language that we're comfortable with that?
No, it would not cause us problems. We'd be moving forward with ours, and as the ultimate owner of the property, we think we can certainly move forward.
And trust me, my questions have nothing to do with OPSB's role. It simply is to make sure that we have the checks and balances in place. And my guess is that we do. It's certainly in a lease arrangement. There's no doubt that you would. If it doesn't cause undue heartburn, I would like to spend a few moments later today with perhaps our attorney and make sure we're covered properly in doing this and get it done correctly. That's my motion.
Okay, we have a substitute motion to defer. Do we have a second?
Second.
Second, Ms. Beebe.
Mr. Chairman.
Do you have any questions? Ms. Dastu.
I have a couple of questions. It seems that we have, I understand Mr. Romer's motion that he wants to talk to legal. I'm going to assume that legal has reviewed this.
And they may
Mr.
have, they can,
Superintendent?
maybe perhaps they can answer the question now. If not, I wanted to give them the opportunity to talk to us after.
Mr. Superintendent, has your attorney reviewed this? And is prepared to speak to it?
The
Any
RSD, the RSD attorneys have.
Our
However, our legal team is not. I'm fine with,
Okay.
with the motion to
Deferral.
defer so that we can have a discussion.
And
on
then
this.
I'd like to suggest that if there are RSD more facilities issues or management issues, there is a standing item in the finance agenda under the master plan, and so that I think we can address some of the, I'm not real clear on what Ms. Hill's looking for, but if she can clarify it, I think we can address it in that standing item without having to create a new one. That's just my thought, if that's acceptable to her. Perhaps the staff could review that item with her and see if that's, and if you're looking for Ms. BB2, a place to have a more robust discussion and have questions answered around RSD, facilities and contracts, it's in the finance agenda. Just a suggestion. Thank you.
Okay. We have any other questions on the motion? Hearing none, do we have any objections to the motion? Hearing none, motion carries. Next item.
And, Mr. Superintendent, with whoever you think is appropriate for us to meet with after or during lunch or whatever, let's get it done so we make sure you get it done.
Absolutely. We appreciate your insight to helping us go forward with that. Thank you.
Okay, next item, please.
Your next item is item 4.2 on page 19. Consideration of an update report on the expiration of conditional supervisory memorandums of understanding. The department recommendation is to receive.
I'd like to make a
Ms.
motion.
Bradford? I'm sorry.
Go ahead. I'll make a motion to receive.
I'll second.
Mr. Romer, second by Ms. Bradford.
Okay.
Mr. Romer?
And I have another motion related to the same item for clarification, so I think we can go ahead and dispense with the first motion. And
Then we'll come back to you,
yeah.
Mr. Romer. Okay. Do we have any questions on this motion? Hearing none from the other BESE members, I do have one. If I understand it right, we are renewing these memorandums of understanding with these schools, some of these schools?
Yes, that's correct.
Okay. Is my understanding correctly, that the original memorandums of understanding didn't quite turn out the results that we were looking for?
Well, that would be correct. And one of the things we're doing differently with these is...
My next question
Yeah.
is, what are we doing differently?
So these won't be as prescriptive. So in the past, the MOUs were real heavy on, just what they're going to do in those schools. But, consistent with what we believe in the RSD, that those closest to children know what's best to do. And so in the revised MOUs, where they're basically, just more of a light touch MOU in the sense that if you don't meet X goals by a certain designated time, and we have them listed in there, and we've negotiated with the different school districts, is that, if you're succeeding in meeting the threshold, then they will seek to either type 3 or type 4 to schools, depending on, what's been successful in the district. And then if not, the understanding is that we'll have these schools in the next RFA, and that they will be up possibly for type 5 conversion. And so what it is, it's not for us to be prescriptive, to have a fee that we've been placing on districts and saying, for X amount this year, these are all the things that we're going to monitor you on. And so basically it's about those districts understanding just the overall parameters and seeking that ultimate goal of either getting over the AUS bar 75 or showing that sustained growth. And so, the talks that we've had with the superintendents that's involved, they've been pleased with the direction we want to take this on, not only just in Baton Rouge, but also around the rest of the state.
Is there any requirement for them to put additional funding into these schools that they would not otherwise ordinarily?
Not required in MOUs, but they need to be able to use whatever resources and have the flexibility to do those things that they feel is basically going to change that situation around. And so it won't be anything prescriptive from the state.
Is there any requirement of site-based management with the principals having more authority than normal?
We're always stressing in those agreements for schools to particularly empower their school leaders. But again, we won't have like step-by-step monitoring to ensure. Again, they'll have to show the progress that they make will be shown, and whether they make progress or not in these agreements, those terms will be clear what the next steps are.
Okay, do we have any other questions?
I do.
Ms. Bopey?
Yes. So I appreciate that that there's not as many directives as in terms of what the schools should do. I appreciate that philosophy. My question is, what kind of supports or resources are provided in terms of helping schools understand what they might do in order to be more successful with kids?
Well, the state, as well as within the RSD, we often dialogue and have our achievement teams discuss different options with schools. And so as the districts are open to it, we share with them, basically having like a dashboard or menu of services that are there. And then also we're looking at how can we collaborate with those districts to help, improve those schools if they seek our input. And so it's an open dialogue, and, we're always welcoming them to say, hey, if we have something that we're doing that we feel can benefit you, we'll do that. Or oftentimes they tell us, hey, we've been seeing, certain models work that's allowing us to be successful, and so we're giving them that flexibility.
Thanks. I appreciate that information sharing.
Yes.
Mr. Superintendent, do many of these schools fall within your achievement zone?
Yes. Except for the ones in St. Helena, they all do. And so that's what's been refreshing about this. And so we're looking at, the overall scope of the zone in Baton Rouge, and what do we do working together on that without being prescriptive, but understanding that empowering teachers, empowering leaders, and then ultimately, if you don't make the progress, that we will Type 5 it. Or if you make the progress, that the freedom that you gave is so much like chartering, you're going to welcome Type 3 or Type 4 in the schools. And so, that discussion has been good. It's been frank dialogue, but quite honestly, to get away from the bureaucracy that we've had with these stacks of literal like steps and monitoring that never really was able to be actualized at the level that the state had intended and RSD had intended years ago. It's a refreshing place to be in, quite honestly.
Good, thank you.
Okay. Any other questions?
Mr.
Lee.
I need a little bit of clarity. It was my understanding years ago when this RSD was first set up and failing schools, that failing schools may go under an MOU or may go under RSD, but it was not automatic. And this seems to be saying that a school will be transferred to RSD. Are we by policy making a blanket decision that in the future failing schools will be under the direction of RSD?
No. In this case, however, we are asking for the board to endorse a specific strategy with respect to these schools as we would in any other instance where a school is coming under an RSD MOU or under RSD governance.
But see, it says if the LEA does not achieve the required school performance score, the school will be transferred to RSD.
Well, but that, Mr. Lee, is as part of the MOU. In other words, we're asking for the board's endorsement of an MOU that stipulates conditions. One such condition is that if the school does not perform, then it will ultimately come under the governance of the RSD.
But is that for any failing school?
No, sir.
That's only the ones that have these agreements right now. So for any other failing school, if we have not actualized yet on that and we go into, an agreement saying that either the RSD or the school would be placed under MOU, then that will be the case. But for these particular schools, it speaks specifically to if the MOU is not continued, then it will come directly into the RSD.
So this applies to this list of schools stated?
Yes.
Only?
It's for these schools that are listed under these MOUs. That's correct.
Because I'm of the impression with the new cutoff score, we're subject to having a big increase in failing schools.
And I think that's part of the reason that Superintendent Dobart's team has proposed changing our MOU focus. For board members, I mean, we can say this as clearly as is needed. The MOU structure where you kind of try a light touch management from sometimes, very far and distant and say, give us X amount of funding to fund this kind of light touch program and then we hope you do these things, hasn't yielded transformative outcomes.
Right.
Where we have brought in new management, an entirely fresh new approach, that has tended to yield tremendous outcomes. And so I think what Superintendent Dobart's team has proposed is let's make the MOU about either you're going to get outcomes or we're going to get outcomes, but we're not going to kind of try to play small ball especially as you're talking about, scores of schools potentially coming into the RSD.
And I would also add, if I may, that this also still gives the discretion to the superintendent to do something other than bringing them into the RSD, actually, if you read it. So, yeah, it says these schools would come into the RSD under the MOU if they fail, unless the superintendent determined otherwise.
And that's correct. And again, the dialogues that we've had with some superintendents who, not this year, but next year potentially could have MOUs winding down. One of the things we're looking at, and it's even the way what we call them. We're looking at them now as shared success agreements. Because to be quite honestly, it's between us to work together to define what success is going to be, and not in an adversarial role, but in one of a support role. And so, for those who are under MOUs, we want to move to this as they're winding down, but we're very clearly, if progress is not made, that this is what the next steps will be. And for those schools, as they start, hopefully we won't have as many coming in, but obviously, as Mr. Lee points out, there's some with the AUS bar going up, that we have to look at that. But we can't, and we won't be heavy-handed as far as prescribing step by step, but we will be strong and resolute in what we believe the final outcome should be for children. And so, and again, we're looking at it as something that's we're sharing in the success, and we want to make sure we're good partners, even though it's a difficult, arena to always be in.
And I hate to keep,
Mr. Romer?
I know you keep recognizing me, Mr. Garvey, and I appreciate it. I think it's important for this board to understand what's happening here. I mean, this is a critical step in our process of how we deal with failing schools. And while I think we can without question say the progress in RSD New Orleans has been phenomenal, we still have progress to make without a doubt. But we've struggled more so away from New Orleans, quite frankly. In our attempt through MOUs and other ways, we've not been as successful as we want to be. I think everyone would admit that. And I think this is a recognition of, hey, we need to do better. And one way to do better is also to make these kind of shared success agreement where we're all in this to try to bring these schools to a better outcome. And so it is a shift in mindset and a shift in policy with these particular schools that I think are critical. East Baton Rouge is facing tremendous challenges with a number of its schools, and we need to find solutions. And I think this is it seems subtle on paper, but it's hopefully not as subtle in outcomes, that it improves outcomes significantly. So I would commend the superintendent for his efforts with the achievement zone and with these MOUs, and we expect as a board, we expect outcomes. And if we don't get outcomes, then we're going to try something different. We know not everything we do is going to be successful. We want it to be. But I think it's obligatory on our part to recognize when we're not achieving what we want to achieve and changing our strategies around that. So I commend you, and I'll use that as a closing statement to move to receive this item.
I want to.
Mr. Lee?
No, you're not allowed.
Yeah, I am. You can't talk and then shut it off. Even though I know you'd like to. I agree with what Mr. Romer just said, but I think we need to also recognize that this is an important shift in governance of public education, and it's an important movement toward control at the state level. Now, I don't have a better answer, but I think we need to recognize what it is.
Mr. Chair?
Thank you.
But I
Ms.
think we
Bradford.
should also put some of the responsibility and control back where it belongs in the local setting. I think that you just can't legislate excellence. You can't legislate, or prescribe everything that's going to help a school be successful. But I think we empower the people who are on the ground in there every day to do it. They are capable to do it, or we have agreed on things that'll happen if it doesn't. And I think this is a great move for public education, to have the teachers and the principals and the people who are closest to it be responsible.
Thank you.
In a new way.
Okay. Any other comments?
And that's all.
And that's all? Okay. Any objections to the motion? Hearing none, motion carries.
I have a related motion, though. I think.
Oh, yes, Mr. Romer.
I think it's technical, but I think we need to take care of it. We are actually making Estruma High into a direct operated by the RSD school, which has not been previously under this policy. So I think we need to make sure that's officially done. And so I make a motion to transfer Estruma High School to the jurisdiction of the Recovery School District to be directly operated by the RSD. That was in this, but it wasn't particularly stated as a motion, and I think it needs to be stated as a motion.
Okay. We have a motion. We have a second. Do we have any questions on the motion? Hearing none, do we have any objections to the motion? Hearing none, motion carries. Next item.
Next item is item 5.1 on page 51, consideration of revisions to Bulletin 129, the Recovery School District, Section 502, Parent Petitions, relating to the creation of a parent petition process as required by Act 2 of the 2012 regular legislative session. The department recommendation is to approve as an NOI.
We have a motion to approve.
I'll move approval.
Mr. Romer, second. Ms. Bradford?
I have a question.
Mr. Romer.
Why do we, I was curious, there was a timeline in here at which point they could begin collecting signatures. Is someone familiar enough with that timeline to discuss it with me?
I'm happy to invite staff down, Mr. Romer, but Mr. Chairman, if you wouldn't mind if I
Mr.
respond.
White?
Thank you.
Superintendent White?
The timeline essentially tries to align the issuing of the letter grade for the school that is the condition upon which this process can actually happen with the need for BESE to respond to the parent's petition in time enough to ready the school for next year. So it's not really different from any other consequence like school choice of the time, of letter grades. It's the same kind of deal. It has to be done by a certain point by BESE in order for it to be ready. On the other hand, it can't really happen until such time as a letter grade has been issued. I think we had the same concern regarding timing. One thing that we think somewhat alleviates it is that there was a preliminary school performance score issued in the summer. On that basis, any group of parents could begin to organize around this question, thus giving them more like a 6-month timeline, more than a 3-month timeline, as may be indicated in the bulletin.
Yeah, and that was my concern, which is if parents knew or had a strong feeling that the school wasn't serving them well, are we prohibiting them from starting a process that in fact may not be needed? The results may come out and the fact the process is not needed or they're no longer qualified, but are we artificially limiting their chances for success with this timeline? I mean, I know there's got to be some limits in there.
Well, I don't think so, because you'd have at least 2 years of a low letter grade previously. Then you'd receive an initial letter grade over the course of the summer that would give you some pretty solid indication as to whether or not the school is going to meet the criteria for the law.
Okay.
And let's say you know that by July. Well, then you have 7 months by which to issue the petition.
Okay. All right. That satisfies me. Thank you.
Okay. Do we have any other questions or comments?
Yes. I have a
Ms. Hill?
question. Yes. Would the petition be used if the parents want to be removed from the RSD, or would it just only be for those parents that want their schools to go into the RSD, or vice versa?
The law already has a process for removing a school from the RSD. As we talked about earlier, the BESE endorsed regulatory process for a school coming out of the RSD. This is a statute that relates specifically to schools being placed into the RSD.
So if a parent, you have a group of parents, 50+1 parents that want the school to return back to the local school district, we don't have a petition. We just have a law that's in place, correct?
There is a law that gives authority over that process to the BESE board.
Okay.
And there is a law that gives authority over this process to the BESE board, meaning that if you enter by way of a parent vote, this would be the process that BESE has adopted for that purpose. BESE has already adopted a process for a school getting out of the RSD. It's fair to say that while parent consultation is a part of that process is not by way of a parent vote. That process is by way of school performance. So the school has to perform at a certain level for 2 consecutive years in order to be released from the RSD.
Ms. Beebe?
Thank you, Mr. Garvey, and I think, Ms. Hill, the explanation offered by Superintendent White, it would behoove us as BESE to change the policy to allow for those parents in the recovery school district to opt out and to request a transfer to their respective district. So that's and I'll put it in the form of a motion if we're in order, if you care to second it.
Are we in order?
To change our policy.
You need to go receive and
Make it.
Right. Mr. Chairman,
Would
may I
you-
may I make a suggestion?
Ms. Astu?
May I make a suggestion that Ms. Beebe and Ms. Hill work with BESE staff? They can prepare, receive, and refer off the board agenda that would create that item, because it would require study. It wouldn't just be making a motion to change policy. This affects contracts and things. That's just the way that you build an item and you bring up policy. It is a way.
I believe that's a
suggestion.
way we've used in the
That's
past.
the way the board does that.
So in essence, we would get with staff, is that what you're referring to?
You would work with staff to prepare, receive, and refer motion that would go on the board agenda for a future meeting, that the department bring back some suggested recommendations and suggested policy language.
Well, okay, then in that case, I'll withdraw my motion.
I'll second.
Well, she's
Oh, you
withdrawing the
withdraw?
motion.
Well, I'll make the motion to receive and
Do
refer.
receive and refer to the department to review policies, the policy around.
Did you get that, Mr. Garvey?
Wait, I'm wondering, do we have a motion on the floor already?
Yes.
We do. Let's clear this motion, and I'll come back to you in a second.
It's a separate motion, it's not a substitute.
Okay. Do we have any more questions about this motion? Okay, hearing none, any objections to this motion? This motion carries. Ms. Beebe?
Okay, at this time, I would like to make a motion to refer and receive. Receive and refer.
To this,
To allow for parents whose students are enrolled in the RSD, if they choose to opt out, they would have the autonomy to do so.
it would be a receive and refer of an item on this agenda. Staff can write this, I know.
Okay. Do we have a second?
I
Ms. Hill?
second.
We have a second. Do we have any questions about that motion? Do we have any objections to the motion? Motion carries. Next item.
Next item is item 5.2 on page 56. Consideration of revisions to Bulletin 126 Charter Schools to ensure alignment with recently passed legislation. Department recommendation is to approve as a notice of intent.
We have a motion? I'm sorry, Mr. Gale? Yes.
Was that 5.2?
5.2.
What about 5.1?
We just
that's what we
considered
just
5.1.
discussed.
Okay.
Okay, do we have a motion to approve?
I move approval.
Second.
Mr. Romer? Mr. Astud?
I have a question.
We have, okay, Mr. Romer?
Under, on page 57, and this is probably, somebody needs to follow, at the bottom it says, it gives the opportunity of an applicant to provide a written response to the evaluation team to questions, and it says such response should be available to independent reviewers. Should that response, does that necessarily prohibit that response from being available to BESE members?
I don't believe, it does not. It certainly is not the intent of that, and I don't think that this prohibits that from happening.
Okay. On page 59, I'm curious, there seems to be actually it starts on page 58, subsection 1303, the extension review. It seems to state that if they don't meet their goals, that the charter shall expire at the end of the school's 4th year. That's what it says at the top of page 59. I had a question. There seemed to be, and I apologize, my notes here are about clear as mud. It seemed to be in conflict with, let's see, I'm sorry. I apologize.
While you're looking, may I make a comment back
Yeah, I
on page
apologize.
57?
Ms. Beebe? I'm sorry, Ms. Bradford.
I mentioned this before, but I think one of the timeline issues on this was the fact that the charter didn't have enough time once they got this to do the things they needed to do, and that y'all were going to be aware to think of that and fix that. So I just wanted to mention that again so that we had it on the record, that that's my understanding, that the charters felt that they didn't get the timeline they needed to be responsible. Back to you, Mr. Romer.
I'm fine. I actually cleared it up. I saw it now. I don't have a question on that anymore. Thank you.
Mr. Chairman,
Okay, Mr. Lee?
if I'm reading this correctly, and I really need a little bit of help as to what anybody thinks, item number 4, I believe it is. No, item 2 on page 56. It says revised charter teacher certification requirements to reflect new provisions of the law. Can somebody explain to me what that is, and do you know?
57.
My off-the-wall understanding, and I'm not sure it's accurate at all, is that the law was changed to remove any certification requirements for charter schools. Yet on the other hand, and they're public schools, yet on the other hand, for traditional public schools, we have very strict certification requirements. Can anybody shed any light on that?
I think what you're referring to, Mr. Lee, is a change the legislature made.
I know, but
yeah.
I'm wondering, what was the reasoning behind that? Why do we have such a difference? They're both public schools.
Well, I don't want to speak for the legislature, but let me give, if I could, my interpretation of it. I think that the legislature was essentially saying, given that we're moving toward a high empowerment, high accountability model, given that charter schools are closed with the swiftest of consequences based on student outcomes, given that that's such a stiff accountability on the back end, let's not regulate the inputs as greatly. And I know that that has provoked some concern. I think we supported it based on the idea that because the accountability was so strong on the back end, that there don't really need to be such strong regulations of the inputs on the front end. At the same time, I'll just tell you my personal view is that a lot of the issues that you hear from charter schools about certification processes are echoed in what you hear about from traditional schools about certification processes. And to the degree that we are, as a department and as a board, interested in streamlining those requirements, I think we should take that up as well, because frankly, a lot of the certification rules, while some of them are important, many of them distract from getting the best people in the classroom.
Yeah, that's kind of the question I have. If it's good for one, why isn't it good for the other? Something don't.
I don't disagree with that. I think conceptually the rationale would be because there isn't such accountability on the back end in the traditional system. In other words, you can't just shut a school down as swiftly as you could in the charter area. They don't have a regular review as they do in the charter schools. That, in that respect, that would be, I think, the response. However, I'll tell you that my view, and certainly what we hear from schools, is that they do feel boxed in by the certification requirements. Now, we've done some things, such as applied for a waiver that we've received so that when schools, for example, aren't in compliance with the highly qualified teacher provisions, they don't need to go through these cumbersome corrective action plans and so on. So I think we're taking strides in that way, but I think it's fair to say that we as a department at least would be more than open to streamlining certification requirements in the traditional system.
Ms. Beebe.
Along those lines, Mr. Lee, I am a strong advocate for teacher certification because, again, to me, that is a standard of measure. But to respond to your question, I predict that it would provide the human capital for the charter schools. And I need to pose this question to the superintendent with regard to those individuals who are ineffective and their license or certifications are suspended. Are they then considered for employment in the charter schools? Have we given any thought to that?
They would be under the law eligible for employment, given that there are not certification requirements. At the same time, it's fully within someone's right to say you're a teacher elsewhere. What's your performance rating? Given that we now have a transparent system of performance rating, if someone were to come and say, well, I received multiple ineffective ratings, I think we have to trust that our principals wouldn't hire that person, given their accountability, that if they don't make academic outcomes over 3 years, their school will be shut down.
Okay, and another question or item found on page 57, in order to go through the charter school application and approval process, why are we asking those individuals to hold valid current Louisiana teaching certificates in the development of the charter application when they're not required to teach in the charter? The certification is not required for teachers within the charter school.
So can you just point to which item you're referring
That's
to?
page 57 under the charter school law bulletin 126, and it just says to submit the application, a group must include 3 or more persons holding a valid Louisiana teaching certificate in the development of the charter application.
And that's an old provision that's there. I think if the board if board staff and wants to work with the department staff to potentially change that to effectiveness criteria, I think we'd be more than open to that. Look, I think we're just talking about mainly a shift from a model that was based on inputs to a model that's based on outputs. And if we want to move to a model where instead of just saying, are you certified as a teacher, we could say, are you certified as a teacher, or you have demonstrated results of strong student achievement, I think we'd be more than open to that. I agree with you, if this is what you're implying, that could be an antiquated policy there. It's not one that we propose to change today, but I think we'd be more than happy to look at it.
No, once again, I advocate for teacher certification. I'm just curious as to why this reflects one thing and then there appears to be a shift from teacher certification in the charter school itself.
Well, we're making a gradual shift. I think we do need some indication when people apply that they have credentials, but clearly the Compass system allows for that credentialing based on results, and so we'd be more than happy to look at it.
Do we need a motion or just a directive for the department to take a look at it?
I think it would be helpful. I think we're happy to take the directive and then report back if that pleases the chairman.
Ms. Beebe, is that what you're looking for? I think it is.
What?
That the department work on this issue and bring something back to BESE regarding this issue.
Well, my concern was the contradiction in language, but once again, I'm an advocate for teacher certification. I want to emphasize that. And page 61 just needs some clarification as to the admission requirements. It says a charter school may have admission requirements that are consistent with the school's role, scope, and mission. Now, once again, can someone elaborate on that? If I'm a school, let's say my mission is to just address like a magnet setting or what have you.
Dyslexia?
Huh?
Dyslexia.
Or dyslexia and so forth. So would there be any discriminatory practice here with regard to this?
No, charter schools may not have discriminatory admissions practices, and these regulations actually take steps toward ensuring that there are not selective admissions processes either. So that, for instance, the new kind of such a magnet type school would not be allowed under this kind of under this regulation.
However, I have a question. I'm
Ms.
sorry.
Hill?
However, but the charter schools are able to have selected process, meaning that they can select those students who they choose to select. So
No, there are a number of schools that were created years back that have been allowed to maintain those standards. However, these regulations actually ensure that schools are not able to engage in selective enrollment and in fact have to have selective random lotteries. There may be schools, as Ms. Beebe mentioned, that, and I believe there's one in your district, for example, that actually do favor particularly disadvantaged students such as students that are dyslexic in the instance of the school in Thibodeau. And, so that is permitted, but there are not schools that are able to select based on, say, academic proficiency.
Okay, Ms. Bradford.
I just want to go back and say officially that I think we need to look at getting the language consistent so that we can be sure that we are consistent throughout all the policies. And that would be particularly to the Chapter 7.
I think the department said that they are going to work on that. Okay, any other questions? Mr. Romer.
I will point out, it's not the goal to make charter schools identical to traditional public schools. So you will find certain things allowed in some instances and not in other. Now, that does not mean Mr. Lee's comments were irrelevant. I think that's a very relevant question, which is looking at the requirements of certification, et cetera, across the board. But the goal here is not to make sure the charter schools have to follow all the exact laws of the traditional public schools. In fact, it's exactly the opposite. Is why we set up the charter school mechanism, which is a chance to allow them outside of the traditional school system to come up with different ways to reach achievement. So let's make certain here our goal is to not to end up with identical policies for traditional schools and charter schools. Now, what we hope is those things that we do learn from the charter schools that are effective, we then allow the traditional public schools to utilize those as well. I think that's a legitimate comment, but let's be certain here. There's going to be differences, and there should be differences. If there's not, then we ought to do away with them. Thank you.
My understanding, Mr. Romer, that Mr. Lee is asking for exactly what you just said. We found something that works for the charters, and he thinks we ought to let it also work for the non-charter, traditional public schools.
Sure,
so
absolutely.
I think it's working as you described. Ms. Bophy?
I'd like to offer a different opinion, and that opinion is that certification is a lever that we can use to raise the standards for the teaching profession, and that I think that we need to look at certification as an opportunity for us to raise the bar in the profession. And so I struggle with this notion that we'll be striking a potential lever that could benefit all of us if we were to go back and look at certification and talk about how we can use certification as a tool. But the question I have now is, can we have more stringent policies than what the law spells out? I understand that the law says that our charter school teachers have to have a bachelor's degree. Can we have more stringent policies for that?
That sounds like a question for the department.
The language says it has at least a bachelor's degree, by the way. So.
And I think what I would, and Joan Hunt can come up and respond, but as she's doing that, what I would say is that by striking certification as a concept as applied to charter schools, and given that the laws give BESE the ability to essentially determine what constitutes certification, the law has effectively taken away a lever from this board. The legislature has taken away a lever from this board to regulating who should and should not teach in schools. Other than that, it said, in charter schools, other than it said that they, for example, shall have a bachelor's degree. And as Ms. Hunt mentioned, in other statutes is mentioned the idea that there are other requirements that they must meet, such as the criminal background check. Joan, is that?
Yeah, I agree with that. And it was the question, can we require certification for charter schools even though the law says not to?
Well, but my reading of the law is not that it says not to. It says that you require at least a bachelor's degree. I didn't read in the law where it says you can't require charter school teachers to be certified.
I disagree. I believe that it is saying that for charter schools that BESE doesn't have the authority to require certification in charter schools. That that's a freedom, just as in the law, like in 1739-96, where all the exempt charter schools are exempt from all laws except the ones that are specifically listed. So the legislature has decided there are certain laws from which charter schools cannot be required to comply. That's a freedom they have in order to be able to be more innovative.
Thank you.
And I think it goes back to the fact that, just what Mr. Romer said, we're trying to create a different entity. And so it's going to be hard. There's going to be some bumpy roads where we try to figure out the path, but they should be two paths towards the same goal.
Ms. Hill?
Yes, I guess I want to go back to my original statement. I think you said that no charter school had a selective process. And I'm just concerned because when we look at the schools that are failing and we have the parental choice options out there for parents, I just want to make sure that children are not being rejected based on academics, regardless of what the situation or what school they come from, geographical areas. But when I looked at chapter, if you go to page 62, and under section chapter 27, if you read that, it specifically states, any charter school which began operation prior to July 1st, 2012, and which incorporate achievement of a certain academic record as part of their admission requirement, may continue to utilize such admissions requirements. So that's stating that they can use their academic achievement record to determine if that child can actually be entered into their school or not. So please help me understand that if we're not allowing charter schools to have a selective process.
Well, actually, what these regulations do is take further steps toward making concrete the fact that charter schools going forward cannot have admissions requirements. There are, as I said, a number of schools, small number of schools that have operated for years with admissions requirements. The law is going out of, or the reg here is going out of its way to say that those schools will not be required to change their admissions requirements. And I believe we're talking about Franklin, Lusher, and is that it?
Lakefront.
There's 2-4, Lake Forest, and yeah, so anyways, you're talking about several schools, and nothing else going forward. I believe all of those schools are located in Orleans, and
they were all magnet schools prior to going charter, academic magnets.
So just to make sure I have a clear understanding, so any new operating charter school that will be implemented, they would not be able to have selective.
That's correct.
Process, prior to those who already, they are grandfathered in.
And those that are not already using any admissions requirements. So in other words, if you exist today, which is the overwhelming majority, that have no admissions requirements, they are not able to suddenly shift and say, well, now we have academic admissions requirements.
Mr. Chairman?
Ms. Dasty.
I just have two questions. Well, one comment and one question. I believe I'm correct in saying that the schools that you're referring to were district charters. In the history of the board, we have never approved a charter that had any admissions criteria. Those were schools that were chartered after 2005, and they were district schools chartered by the districts. I just wanted to make that distinction. The board has been very consistent that we don't believe that admissions criteria is appropriate in the schools that this board has acted on, as far as I know through history. And secondly, is going back to the certification question, is there anything in the law that would prohibit a school, a charter school, from saying that they want all of their teachers to have, say, masters?
No, there's nothing preventing that.
So what this does is give the school flexibility to determine the credentials and the talent and experiences that they want to create success in those schools. Am I correct?
Correct.
Okay, thank you.
Okay. Mr. Romer.
I apologize, I'm talking too much today, but I've been unusually quiet lately.
Not quiet enough.
I know, thanks, Walter. I think the certification issue is an interesting one, and one that should be discussed later in more detail. I do agree with Ms. Bophy that we should use our certification as a label of excellence. I think that needs to be a goal of certification. I don't think, however, that it's inconsistent to allow a school to make decisions on hiring and firing of its own personnel beyond just the certification requirement. That certification in and of itself should be a sign of quality and excellence. I would argue thus far I don't necessarily believe that it has been in every instance. I think the record shows that to be true. So we ought to work on certification to make sure that it is a label of excellence. But secondly, I actually don't even agree with provision that we require a bachelor's degree. I mean, ultimately, what we hold accountable are the schools for the results. And you can find instances of individuals who have neither a bachelor's degree nor a teacher's certificate, who could be excellent teachers in a particular field that require particular skills. And I actually believe we ought to give that authority at the school level to make those decisions, and then we hold that school accountable for its results. Now, That doesn't mean we do away with certification, but we ought to make certification, it would be nice to know that that is a label of excellence, so that when I do get an applicant that is certified, I know that is a certification of excellence, and hopefully a school would want to hire that person. I don't know that we're there yet. And given that we're not there yet, I would like to give the authority at the school level to make decisions if, in fact, we can hold that school accountable for its results. And I think that's what we're trying to do in this instance, is give more flexibility to the charter schools to make those hiring and firing decisions, knowing that, in fact, within a 4-year time period, we may take away their charter. So it's in their best interest to perform. And if they can find an individual without certification, and I would argue without a bachelor's degree, although that's in here, and I'm not going to try to take it out, that we should give them that freedom. But it's a good question, and it's one that we need to focus more on in terms of making certification a real label of excellence.
Okay, Ms. Beebe?
One final comment, and you know my stance on certification. And I have done, and I'm going to make this personal because I've done my due diligence to attract certified and highly qualified teachers in my district. And as we move forward with this new legislation, and as I facilitate the hiring process with my school administrators, I have just this last week refused a principal who recommended to me an individual who lacks the certification. And I said, as long as I'm in the personnel department, and of course it is law to hire certified teachers, I will stand by, and they will have to honor the certification first. And, you know, we can have the debate back and forth, and I know I'm not going to convince you otherwise, Mr. Romer, but once again, it's a standard of measure. Now, I do recognize, I've been in the classrooms, I've observed teachers, substitute teachers rather, they're not even, well, they're degreed, but they lack the certification. It's a born talent for them. But I mean, this is, to me, a rarity.
I agree.
Once again, that certification is the standard of measure.
And I can just say, I don't disagree with you, Ms. Beebe. I don't believe that certification is a bad thing. I'm just not certain that it alone is the standard. That's my, and certainly there are some fields where certification is absolutely required, special ed and some others that without it I'd be very hesitant to hire someone. But there are other instances where it may not be as required. But I don't disagree with your premise.
Okay, finally. No more comments, it looks like.
I do actually make
Oh! Spoke too soon. Ms. Jones.
I think it's been a good conversation, and I actually agree a lot with what Mr. Romer said, and also what Ms. Bulkey said about the role certification can play in raising the standards of the practitioner, which feels very important. I would also say that I think we are not yet there yet, and so that does, I think, require more work to be done. In my experience working with schools that are achieving results that are charters, my sense is that if certification was synonymous with an actual standard of excellence, that would be something that many schools would actually take into consideration in their hiring processes. But we would have to ensure that there is a direct link between certification and excellence in order for charters that are achieving results to actually consider that as a part of their model, is my sense.
Okay. Quickly. Any objections to the motion? Motion carries. Next item.
Next item is item 5.3 on page 63, consideration of the creation of Bulletin 133 scholarship programs. Department recommendation is to approve as a notice of intent.
Mr. Chairman, I move to approve as notice of intent.
Ms. Destu? Ms. Bradford? Mr. White?
Mr. Chairman, if you wouldn't mind, I'd make a couple comments just to frame this. This, as with the past two items, the parent petition item and the charter schools item, is a bulletin meant to reflect the legislation. So what you have in front of you is a package of regulatory items that essentially walks through the procedures of this program and is largely just echoing the statutes. It walks through the school registration process, the school enrollment process, the finances, the continued eligibility for schools as per the law, and reporting. I would call out just two things. Number one, it does build on authorities that the board has by way of the MFP resolution. And in particular, that authority is exercised in the form of a proposed tuition regulation, a regulation regarding tuition growth on an annual basis. This bulletin does not address the provision of the law that says that additional criteria for participation shall be proposed by the department. We are developing those in conjunction with educators and experts from across the country. We're not finished with that process yet. We will ensure that the board sees our proposal before it goes forward, before anything is decided on, but decided because it was not finished at this time not to bring this to the board for this piece of the agenda. So I want to say that first, most of this is already in the statute. Other elements of it are procedural, and we're happy to walk through it. One element that's not procedural regards the regulation of tuition, which is not in the statute. That's in the board's MFP resolution. And that the accountability and criteria for participation we're still working on and will bring to the board when appropriate.
Mr. Superintendent, I have a couple of questions. Regarding the increases in tuition and the limits on the increases in tuition that are in the MFP, is there anything prohibiting us from putting that into policy so that it's more clear? Because some people read policy, but they don't read the MFP.
Yes, and the MFP...
And I'm asking because the newspapers have not picked up on this issue, and I think it's because we just aren't publicizing it well enough.
Yes, the MFP stipulates that the board has authority to limit tuition increases to a percentage of the MFP in which the MFP allocation, in which the participating school is located. And that's what you have proposed here today. The proposal is that a school be able to raise its tuition to a percentage, in this case 2/3, of its local MFP, and if it is already at that level, be able to raise it 5% of the annual MFP allocation per annum, but not, for example, to be able to raise it at 100% or 75% or whatever it is of the local MFP.
And that is in the policy.
That is in this policy, but it's the authority given the board is by way of the MFP resolution, not by way of the statute.
I see what you're saying. And a minute ago you mentioned that further policy on accountability is being worked on, and that your anticipation is that that will come to the board before going public or in conjunction with going public?
My anticipation is that it will be developed in conjunction with the board, and we are committed to that.
Do you anticipate that that might require a special call BESE meeting?
I don't know yet what the appropriate procedure is. We want to work with you and other board officers to determine what the appropriate means for that process is.
Okay. Board members, do you have any questions?
Yes. Oh, go ahead, Bibi.
Ms. Beebe?
Page 72, Chapter 9, continued eligibility. I just need clarification on item B and C, because it says that if the school elects to withdraw from the scholarship program, it shall notify the department. And then it says that if the schools that the students of those enrolled in those schools that receive the scholarship, they will continue to have the students enrolled at their schools, and as long as the students want to remain, or is there a condition there? Is something missing in this particular item? Is it just for the school year or indefinitely?
I'm sorry, you're referring to item B2, is that right?
Yes.
That is indefinite. This is if a school elects to withdraw from the program. The question would then be, so what happens to the students? And obviously, if that were the case, and we certainly hope we don't get there, but if that were the case, we can't force a school to take new students, obviously, because they're electing not to participate. However, if there are students who wish to remain there, we're hoping not to take that option off the table And we would hope in that case that if students really wish to remain there, if the school is doing fine, but it simply is not willing to participate any longer, we'd hope to be able to work something out with the school where the school could continue to have those students go on through the school.
Okay, and hypothetically, let's say that school is not performing to expectations, the success is not there. What procedure do we have in place at that point in time? Is it still the parent's choice to have the child remain in the unsuccessful scholarship school?
Well, I think there are two different circumstances here. This is if the school specifically elects to withdraw from the program, meaning that it wasn't anything to do with the performance of the school that forced the school to not participate. It was that the school said, we are not going to participate any longer. In that case, if we could convince the school and work with the school to keep those kids there, then there wouldn't be the cause for concern that you're addressing. If under the law a school is declared ineligible to participate, and as you see that under item A, there is a long description of criteria that require the school, that the law requires the school to maintain in order to participate. If a school is declared ineligible to participate, then you skip down to item C. If it says, if a school withdraws from or becomes ineligible to participate in the scholarship program in the middle of the school year, it shall allow all enrolled recipients to remain at the school for the remainder of the school year and shall pay for the educational services of those students. Then you move down to item E. If enrolled in a participating school that fails to meet eligibility criteria established in this bulletin, scholarship recipients may transfer to another participating school for the succeeding school year without loss of eligibility. So in other words, if a school is simply said you're not eligible to participate, then the students have to be allowed to continue. The students are then given priority admissions to other schools elsewhere. That's a different thing under these regulations from if a school meets all the criteria but simply says we can't choose to participate, we can't take new students. We would hope to be able to say, well, can you at least keep the students that you currently have?
But once again, and I did have this experience in the traditional public setting where students were offered choice, but some elected not to participate in the choice. So what I'm saying, there are situations where students enroll in a school and they may, they will develop friendships and what have you. I'm just asking, would they be allowed to continue although it has been proven that the program is unsuccessful?
Well, if you look at these criteria, essentially what has this school has basically not abided by the law. Thus, it's not participating. Thus, it's not going to have kids. In other words, no, students will not be attending this school any longer. However, we are saying that we think students under these regulations should be able to stay for the duration of the school year and will be given priority admissions elsewhere. Now, I will say this, at the same time, if there are other criteria that are brought before the board that make a school eligible or ineligible to participate, we would also want the board to consider whether under those criteria students should be able to stay. So I'm not taking off the table for future discussions the question of whether or not a student should be able to stay subsequent to the school being declared ineligible to participate. However, these criteria are in the law. A school, by not abiding by these criteria, has broken the law. Thus, we're saying that a school is not able to participate, thus it's not able to keep its kids.
Thank you.
Okay, Mr. Romer.
I know you said that with great regret, Mr. Garvey. Let me see if I understand on page 69, paragraph F1A. Now, it is possible for a current gifted and talented student to be attending a school that's a C, D, or F. That is possible in Louisiana. Do we, and we currently within the MFP formula, give a weight to gifted and talented? if a student, is this saying that the scholarship would not receive that same weight?
It is saying that the law says that the scholarship student will receive the average, or up to the average MFP for students in that district, which is inclusive of all weights.
Okay, good. All right, that's it. Thank you.
Ms. Bophy?
Superintendent White, is there anything in this piece that is different from the law or an addition? Or
Yes. I mean, there's a lot of process detail here.
Okay.
There's also, I think probably most significantly, the tuition regulations are not in the law. The law regulates tuitions by saying effectively that you can only charge the government what it is that you are charging a privately paying student, and no more. And of course, that remains in place. However, we have also said that the rate at which you are able to increase your tuition should also be regulated by way of this policy, which says only up to 2/3 of the local and state MFP shares. And if you're already at that level, then at no greater rate than 5% of the local and state MFP annually.
Thank you.
Any other questions?
Yes, I have a question. Just
Ms.
maybe
Hill.
some clarification. In section B, page 65, it states, section B and C, it states that whether the school elects to offer an enrollment preference for a student based on the parish in which the student resides, any other information required by the department. So could you give me some clarity on that? Just like what additional information in reference to the scholarship?
I'm sorry, Ms. Hill, which item are you talking about?
Oh, page 65.
Okay.
B, participating schools
Yeah.
shall. And then you
Okay.
see B and C under section 1B, 1C.
Yes. So 1B in the law allows for a non-public or public school participating to say, we would prefer to give preference to students located within our parish. For example, in Orleans right now, in the Orleans system, the one that's up and running currently, there are schools in Jefferson Parish that serve kids coming from Orleans. Ostensibly, those schools could say, we would prefer to serve Jefferson kids first and then Orleans kids, or same with Orleans schools. Second, I mean, item C is just simply saying that if the department requests other information about the school, then the school shall provide it.
Okay. Any other questions? Okay, any objections to the motion? Hearing none, motion carries. Next item.
Next item is item 6.1 on page 74. Consideration of criteria for participation for the scholarship program as created by Act 2 of the 2012 legislative session. The department recommendation is to defer.
So moved.
Mr. Estu, Ms. Bennett, Mr. Superintendent, any comments on that, please?
Yes, Mr. Chairman, thank you. As you know, we have been speaking with educators, experts in Louisiana and across the country, as well as with consulting some board members on this issue, and I think it's fair to say that there is still a lot of discussion to be had with educators in particular, and as a result, we're not complete yet with this policy. There is a mandate that this be done by August 1st. We will have the policy done. We have been working with board members and will continue to work with the board on this specific policy, but it was not ready at this time, and thus we are proposing for it not to be heard by the board today.
Mr. Chairman,
Mr. Estu.
maker of the motion, board members and Mr. Superintendent, I have both solicited and unsolicited offered you a lot of input around this issue, both my personal feelings and feedback and that I've received from other individuals. I feel like you're taking that input. I feel like you're taking it into account in your decision making. I would urge all board members to take this opportunity between now and August 1st to meet with the superintendent, reach out to him individually, and offer him your suggestions. I do expect that the policy that you bring forth will be collaborative and will reflect the input of the board. And I have no doubt that will happen. Thank you.
Any other comments? Do we have any
I'll
cards?
have a comment.
Mr. Romer.
The legislation that was put forth regarding this issue gave the authority to the superintendent to craft much, if not all, of this policy. I think this board has a high level and a record of setting standards of accountability, and I think we would expect the same in this instance. This board, for the most part, has expressed its support for the scholarship program. At the same time, we want to make sure there's adequate safeguards in place to protect students and taxpayers from both educational fraud and financial fraud. And thus far, my discussions have been very positive to that effect, but I just wanted to reiterate what our expectations are as a board in terms of what this policy will look like. And though the legislature has indicated the way they want it to be crafted, it should be clear we have other means of making sure we get to the result we like. So I appreciate your input and appreciate you taking your time to make sure you get this right. I know you've had numerous meetings with a variety of stakeholders. I expect you to continue to do the same, and I appreciate the input you've taken from me, and would expect you to continue to do that from me and other board members as well. I appreciate it. Thank you.
Mr. Romer, thank you for the comments. I couldn't agree more with your comments on high standards and high accountability, and I'm hearing that from other BESE members too. Any other comments?
Mr. Garvey, I do have a question, a procedural question.
Ms.
Item
Beebe?
4.3 was under the consent agenda, and I did have several questions.
Would you like to readdress that? You'd like to make a motion to readdress that item?
Please. Yes, sir.
Did you vote on the motion?
Oh, I'm sorry. We have not finished voting on this one.
Oh, I'm sorry.
I'll come to you in just a second. Do we have any objections to this motion? Hearing none, motion carries. Ms. Beebe, you'd like to make a motion to reconsider an item on the agenda?
Yes, 4.3, the consideration of the Recovery School District Early Head Start items. And I just have a few questions.
Second.
Okay, we have a second. Do we have any objections to that motion?
Page 20.
Which item was it?
4.3?
4.3, that's going to be on
4.3,
page
and actually the
page
supporting-
20.
Any objections to that motion? Hearing none, motion carries. Item 4.3.
Thank you, Mr. Garvey and members of the board. I just need some clarification regarding the information provided to us, and it appears that the contract or the information is for a period July 1st, 2012 through December 31st, 2012. And then on page 30, bear with me. There is a sum of money, and I just need clarification because it seems like an exorbitant amount regarding the expenditures, and it appears to be a duplication of services. First, I would need to ask, am I correct in my thinking that we're addressing 104 students in this particular document?
We're addressing 124 students. 104 students are served in centers. So those are students who are provided with full-day, full-week services, and the remaining 20 students are served via the home-based option of our program.
Okay, and there was a sum, I think was it $1 million? I'm looking for that budget, and I apologize. Should have had it marked. Moving forward, I'd do a better job. It's on page 22, $1.1 million. That's the program operations. Could you offer some explanation as to, is this the timeline from July to December, as I pointed out?
Yes, correct. So that sum refers to the total funds that are allocated for the program for that period. If you're inquiring about the unusual nature of that time period, Our funding going forward has been divided into several shorter time periods, and it relates to changes with the federal government regarding early Head Start calendars across the nation. The fiscal year for the early Head Start programs has changed, and it created a gap period. Previously, our fiscal year has been October through September, and the federal government is changing that to a nationwide to a January to December funding year, which creates some changes in the calendar. So this application represents an application for funding that goes through December, and it's and that sum represents the funds that will cover the entire program for that period. It also includes a non-federal share, which the district contributes to the grant program, to the funding that we receive from Early Head Start.
Okay, and the only other observation is that it appears that there could be a duplication of effort regarding professional development and.
Could you clarify what your concerns are specifically?
Well, like for example, the P-card entity, there's a contract providing data analysis that's collected, and I know that's their role, and also job-embedded coaching and mentoring for the teachers and the child care.
Yeah, I'd love to speak to that. As I've pointed out before, the foray into infant and toddler services for our district is new. We have a great deal of experience in early childhood, but those services have been limited to 3-year-olds. And so I just want to reiterate that this Early Head Start program is for infants and toddlers. The job-embedded mentoring and coaching is for teachers who are providing services to those infants and toddlers, and we're working with the P-Card Center to provide that coaching and mentoring. Because this is something that we are embarking on newly, it's a service that we really have relied on from the P-Card Center because they're the experts in that area. Going forward, as we submit subsequent applications, you will find that the reliance on P-Card services greatly reduces. And that will be, you'll be receiving our application for the next fiscal year, actually within the next 2 months. And we're gradually scaling back our services with the P-Card Center.
But ultimately, the cost for the program is $1.1 million?
Well, $1.1 million is the total program operations. The cost of the, but the P-Card contract is a very small portion of that. Currently, I believe our contract for the current year is $120,000 annually. You'll see a reduction to almost a third of that in our coming fiscal year. So as we become more self-sufficient in the area of serving infants and toddlers, we're scaling back our reliance on that organization. But it was really something that we needed in the startup phase.
And again, we're looking at 124 students approximately?
Yes.
Servicing, and this amount covers those students?
Yes.
Thank you.
Okay, any other questions? I'm sorry, do we have a motion on the floor?
We need a new motion to approve.
That's what I thought. We have a motion to approve this item. Ms. Bradford, do we have a second? Mr. Bennett, second this motion?
Yes, I will.
Thank you. Do we have any objection, Ms. Hill?
No, I have a question, but go ahead.
You have a question about this
Go ahead,
item?
you can just go ahead and-
Okay. Any objections to the motion? Motion carries as it did before. Okay, Ms. Hill?
I have a question. I just want some clarity, but the item has already been approved.
Yes,
But I
ma'am.
just need some clarity on the item, so how can I?
You have a motion to reconsider the item.
Yeah, I just want some clarity.
Can you make a motion to reconsider the item, which,
The one we just approved, not this one, the one before.
Is it
With the
something
scholarship program.
Is it something you can get with the department offline and clarify, or is it something you want to be done
I just want
formally?
it to be clarified on the record.
Make the motion, Carolyn, I'll second it.
Okay, I'll make the motion to reconsider.
okay, motion to reconsider item 6.1?
Is that
Second.
6.1? Is that what it is?
No, it's
5.3?
5.3, correct.
Okay. We have a motion, we have a second. Any objections to the motion? Hearing none, motion carries. Item 5.3.
Okay, maybe superintendent or maybe one of your staff members can, went on chapter 9, section B, and section C, which is page 72.
Could you speak up, Ms. Hill? We're having
Okay,
trouble
sure.
hearing you.
It's
on this
chapter
side.
9, page 72, section B and section C. I'm just trying to get some clarity in reference to the, what's the difference, because when I read the information, it's saying that they will pay out if the students are currently there, but if they withdraw, that they would not pay out. And what is the timeline for the withdrawal process? You understand?
Sorry, what is your question?
My question is, in section B, it says that it will pay. In section C, it says that it will not pay. So, as far as the scholarship. So, could you give me some clarity there? Because it's kind of like misunderstanding, the two conflict with one another.
Well, what I read is that it says in Part C that it shall pay for the educational services for those students if a school withdraws or becomes ineligible in the middle of the school year. That piece of the regulation is really just there to highlight what happens in the middle of a school year if a school withdraws or is forced out of the program.
Okay.
It shall pay for the educational services. If a school elects to withdraw, then essentially it will not get more students, but it doesn't say anything about whether or not it has to pay for the students for the rest of the year, because ostensibly that timeline happens in a time other than the middle of the year.
Okay. So the withdrawal time will be in the middle of the year?
No, I think it's saying that there is a timeline established by the department. Presumably the department would not establish a timeline that would set up schools to withdraw during the middle of the year,
Okay.
obviously. However, so then it goes on to stipulate, but if it does withdraw during the middle of the year, it must pay for the student's education for the remainder of that year.
Ms. Astor.
We've already actually discussed this very section for quite a while. I'll make a motion to call the question on the
Okay, we
item.
have a motion to call the question. We have a second? Ms. Bradford? Okay, that requires a 2/3 plus one vote.
To do what? I didn't sorry, if I'm out of
2/3
order.
plus one vote to call the question. Can we get do we have any objections to calling the question?
No.
Hearing none, motion carries. Can we get a motion to adjourn?
So moved.
Mr.
Second?
Chairman.
Any
Mr.
objections?
Chairman,
Mr. Lee?
Finance Committee will meet at 11:30.
Okay, motion carries. We are adjourned.
Board members, staff is requesting that you remain seated and we'll begin immediately because we are pressed for time.
BESE members, if you could take your seats, we would like to get started.
Finance Committee will come to order. Administration and Finance. Administration and Finance Committee. Okay, roll call.
Ms. Beebe? Ms. Beebe's present. Mr. Bennett?
Here.
Mr. Bennett's present. Ms. Bophy? Here. Ms. Bophy's present. Ms. Bradford?
Here.
Ms. Bradford's present. Ms. Dashew? Ms. Dashew's absent. Mr. Garvey? Mr. Garvey's present. Mr. Gio?
Present.
Mr. Gio's present. Ms. Hill?
Present.
Ms. Hill's present. Mr. Lee?
Present.
Mr. Lee present. Ms. Orange Jones?
Present.
Ms. Orange Jones present. Mr. Romer?
Here.
Mr. Romer present. Chairman, we have a quorum.
Good. Okay, first item.
Your consent agenda is ready. We are adding items 5.3, 6.1, 6.3, and 8.1, and we are pulling item 2.5 off of the consent agenda.
Okay, we have a recommendation. Is there a motion? Have a motion to approve the consent agenda. Is there a second?
I'll second that.
Okay, we have a motion and a second. Any further discussion? Any objection? Motion carries. So we're pulling item 2.5.
Right. We are now on item 2.5 on page 38. Consideration of LDE contracts approved by the co-chairs of the Administration and Finance Committee, the BESE President, and 2 other BESE members appointed by the co-chairs of the Administration and Finance Committee. The department recommendation is to receive. We are pulling this item because there is an additional contract that was approved by this delegated subcommittee. It was not included in the packet when it was originally mailed out. You do have a copy. There was a copy emailed to you, and you also should have one in front of you right now.
Oh, well, that disappoints me. I thought this item, the reason for bringing it up was to remove me from the approval. You can still do that now. Okay, so this item is for consideration and approval. Is that correct?
No, these 2 contracts have already been approved. The board needs to receive.
I'll move to receive.
Okay. Motion and second to receive the report. Any discussion?
I do have a question regarding the emergency contract, and certainly I recognize the fact that there are deadlines, timelines established. But it appears that we're getting a number of these contracts, and I just want to voice my concerns relative to the number of emergency items. Does anyone care to speak to it?
Ms. Ciano?
I'll just say that, a point noted, I think we are, and I share the concern about the process for how the board has been notified of these instances. We're going to take corrective action to make sure that we have a better process, and I'll work with Deputy Superintendent Ciano to make sure that happens, but I share the sentiment.
I appreciate it.
Mr. Chairman?
Ms. Dusty.
I think this would be a really good time, particularly with the finance chairs, and not Mr. Lee, obviously, as well, but I think with Mr. Guillo as the co-chair of finance, and any other BESE member who wants to maybe get a little deeper on information around contracts. It's always a difficult, and it's a huge task and a big responsibility. If we could organize something with Ms. Ciano and with BESE staff, we'll be happy to set that up. Mr. Guillo and I have had the same conversation. So, thank you.
Okay, any further discussion?
Okay, we're going to do a contract briefing. I think I can say that a little more succinctly.
We got to act on it.
With Ms. Ciano and BESE staff, and any interested BESE member.
Okay, if there's no further discussion, is there any opposition to the motion on the floor? Seeing none, motion carries. Next item.
The next item is item 4.1 on page 64, a consideration of discussion of the MFP formula. There are actually 3 motions that are required under this item. The first is the approval of the MFP studies agenda, and the department recommends that you approve.
Ms. Ciano, any comments you want to make?
It would be appropriate at this time if for some reason this agenda needed to be added to. The board usually would give us some sort of idea of what it might want us to explore. Not that that can't be done at a later date, but these are the things that we brought forth today that we feel need to be addressed over the next, 6 to 8 months.
Okay, Chair would entertain a motion.
I'll make a motion to approve. I'd like to make a suggestion to add to the study agenda.
Let's get a second to the motion first. Is there a second? Okay, we have a second.
The board consider whether or not it should include prospective language in MFP resolutions going forward.
I hadn't heard that before.
We put that on the study agenda. That wound is still fresh.
Maybe this will be a healing process.
Mr. Lee, could you clarify that request, please?
I'll ask the superintendent to clarify it. That's a discussion between he and Ms. Dusty.
I believe that some of the there have been people who have said that the language in the current MFP resolution looks at impact in years hence, and that's not appropriate for a resolution that is supposed to address this year specifically, and that was raised in some difficult discussions, and we will consider it putting such stipulations in future MFPs.
Right. In future resolutions, future years.
Future years, yeah.
Any further discussion? Okay, we have a motion for approval. Any objection to the motion? Hearing none, motion carries. Next item.
The next motion under this item is to receive the FY 2010-11 70% instructional evaluation results, and the department recommendation is to receive.
You have that information in your packet. The chair would entertain a motion to receive the 70% academic requirement.
I'll make a motion to receive, but...
Okay, we have a motion. Is there a second?
I'll second.
Motion and second. Mr. Romer.
I'd like to add to future reports an item, a column, if possible, Beth, Messino. In addition to the accountability score, maybe the previous year's accountability score as well. Because I'm just interested in the trajectory of some of these schools. I mean, there may in fact be a school that's not spending 70% for whatever reason, but the trajectory of their score is excellent, I'd certainly like to know that. I think it's relevant information, and vice versa. Is the trajectory going in the wrong direction? So if we can include an additional year, the previous year's score, in another column, that'd be useful information for me.
Are you suggesting it for all the districts, or
Yeah,
just the ones
on
below
page
7?
on page 67
Yeah.
and 68. You know, I would include it in all. I certainly would include it on those that aren't spending 70%. But I think it's probably pretty easy to do it for all of them.
Right, and as far as the data element, that certainly can be done. The main reason it's here is because that is the provision, the waiver that you yourselves had adopted, that if they are, you know, failing, but yet they have good outcomes, they get a pass with regards to compliance. But we can certainly add, you know, that data on this sheet for you in the future. Be glad to.
Thank you.
Any other
Mr. Lee, and
discussion?
just additional clarification, Ms. Beth. So those districts that don't meet the 70% instructional requirement and they are failing, what is the procedure? I mean, is there a process in place where staff meets with the district heads and discuss ways to corrective action?
Right. For those districts that do not meet the requirements, we have a process that we require certain actions from them. When they do not meet it, and the scores are, you know, don't qualify for the waiver as well, then we send them information and ask that they do a corrective action plan, a detailed corrective action plan on how they're going to look at their expenditures, even to the extent that they examine certain ways that they can save money, perhaps on their non-operational costs, and that they detail that out for us by our due date. And then we monitor that throughout the year to see whether or not that's helped them any and what if their actions have actually been implemented. And we do come back to the board and report to you on those activities as well.
Now, do you have instances where you have consecutive years where they're violating the corrective action process?
Well, we do have some districts who have had challenges that have existed for years that have not allowed them to meet that requirement. They're really special circumstances, and we try to note that on an annual basis, whether or not that special circumstance. Like in a very rural district, there's a couple of them who have always told us that their transportation costs are so high, it will be always be very difficult for them to reach that percentage. But we do look at that, and we do. There are some that have, you know, had it for multiple years. We ask them to go back and tweak every year. You know, perhaps things that they've tried in the past have not worked, and therefore we try to encourage them and give them assistance on other things that they may need to look at. So we do that on an annual basis.
Thank you.
Any further discussion? Any objection to the motion? Motion carries.
Okay, the last motion on this item is a status report of the student-based budgeting pilot, which that report starts on page 73, and the department recommendation is to receive.
I'll make that motion.
Second.
I have a motion and a second to receive. Any discussion?
I would like to say a few words, if I may. Mr.
Okay.
Chairman. As you know, we embarked on this student-based budgeting pilot over a year ago now, and I just want to emphasize what a good learning experience it has been. I think that was the initial intent of the experience amongst the districts and the department to look into this activity and see how it would benefit our districts. I certainly appreciate all the cooperation and the dedication of the districts who did see this initiative through, and I think their insight perhaps will help us build some tools. Is our goal is to have tools available from the department should other districts decide to look at this in the future. We do have two superintendents today, Mr. Tibby Martinez and Mr. Philip Martin from the districts that did participate that I think would like to say a few words if that was okay with the board.
Please.
Superintendent, did you want to make some comments? Tippy. We got the bad leading the bad here now.
I'm telling you.
got
Good morning. I'm Philip Martin, Superintendent, Terrebonne Parish. When we began this endeavor, we were piloting student-based budgeting. As we began this endeavor, most of us had not heard the term and were not very familiar with it, so it was kind of a foreign term to us. When we first began, we moved from looking from some type of format or recipe that defines student-based budgeting. Give us a rule book, and we want to follow those rules. With Beth's guidance and many people that came to speak to us, we began to slow realization it's not about a rule book, a recipe, nor a format. Student-based budgeting is a concept, more of a philosophy than an ironclad set of rules. With student-based budgeting in Baltimore may not be the same as student-based budgeting in California, and it can be whatever you choose to make it. What the concept it is, it's to empower those, and we came to this realization, to empower those closest to the children to have impact and control over the utilization of resources, typically money. Let those closest to the children make decisions how those resources will be best in the interest of the kids. When we came to that realization, we almost simultaneously came to the realization we are very close. When I say we, I'm speaking in my district, in our district. We're very close to student-based budgeting as we speak. We probably just didn't know we were doing it that way, because we do empower principals. We do give the local communities great control over how the resources are utilized in their schools. As Beth said, it was very informative, very steep learning curve for principals when it comes to finances. They began to realize it's so much more than just teacher salaries. That you do student-based budgeting, things they've never had to worry with. When a teacher has a lot of sick days and has unfortunately sickness out for a long time, they go hire a sub. That wasn't their problem. Sabbatical leaves, maternity leaves, the cost of insurance and retirement, those things have not things that principals focus on or have much awareness of, quite honestly, in their day-to-day life. So it was very informative for principals, and I think they learned a great deal from this endeavor. We're planning to pursue still refining what we do in our district, and it's been mentioned in some of your proceedings earlier today and some recent legislation. Principals have been empowered by this legislation, and we will continue to empower principals and schools to make decisions as they see fit to impact children in positive ways. One thing we learned student-based budgeting does not do, it does not manufacture any money for you. It doesn't crank up more printing presses and say give you more. It's just a utilization of what you have. And as dwindling resources and increasing expenses, as you combine those two, it even becomes more imperative to utilize all resources in the most effective manner. So we appreciate the opportunity to participate. It is an important tool. It's not the silver bullet, but I do think it's a valuable component in that continuing the drive for increased student achievement. Thank you.
Good. It's been quite an experience, okay? The principals come back and forth to you.
Kip, do y'all mind telling us who you are? I know
I'm
some
sorry,
of us
Walter.
know, but everybody might know.
Timmy Martinez, Superintendent of Assumption Parish Schools. Like I said, it's been quite an experience for myself, for the principals. I need to give credit to the business managers, to the principals, and to the State Department staff for putting it together and coming up with a pilot. We jumped in it because we wanted to be part of the pilot, because we wanted to set the rules for student-based budgeting or help develop the rules for student-based budgeting. I have 10 schools. All 10 schools are in it. So we're all going through it at the same time. It's a matter of prioritizing, a matter of sharing, a matter of thinking differently. Okay? Maybe I had an instructional coach this year and I can't afford an instructional coach. So me and the school down the road have to share that instructional coach. Or maybe I had a counselor and I can't afford a counselor. So maybe I have to share it with another school. Or I need this teacher instead of whatever. They're making all the decisions in the personnel. As Philip said, it's nothing new for the principals to make decisions on personnel. They've always made it in the past. They are sent, the teachers and the people that work in their districts, their support staff, and they make the decisions as long as these people were certified. And that was the only time we overruled them at the central office. If they weren't a certified teacher or certified particular position they were making. The only thing, the money is tight. Some schools had to struggle. We had to put some added weight on the smaller schools because you might have third grade at a small school with 38 students or 36 students. Well, you don't want to put one teacher there, so you have to have additional teachers. So we do have to put some add-ons in different places and adjust it. The only thing I need to look at and to see how much time it's going to take with the principals. The principals have been working with the business department and the business manager and accountants and making these decisions on what they're going to do. And I want to see how much time this is going to involve in our principals throughout the year. So it's going to be quite interesting looking at this, and hopefully we'll be successful.
Excellent reports. Any comments, board members?
I just have a couple of questions. I mean, we started back on student-based budgeting quite a while ago, and I do appreciate the districts that have engaged on this. And you're right, you get to shape and set the rules, as a pilot district. That's and I understand that it takes a certain type of leader and business manager and principals to be willing to think differently and to act differently, and I commend both your districts for doing that. Is there, you said all really strong positive things. Is there anything that either BESE or the department could be doing to further support the work that the challenge that you've taken on around this? And if there is, we're here to help you. I know you've heard that before.
Unless you want to send some money, I mean, we'll always take that.
Well,
we've got support from Beth and from Charlotte. Whenever we pick up the phone, they've helped us out as much as we could, as much as they could, and work with us.
Has it resulted in the shifting of dollars, more dollars to the classroom or to the school? I think that's the ultimate goal, right, with student-based budgeting, is to be able to more strategically allocate resources and put as much as you can closest to the child. Do you see that happening yet in your budgeting and in your experience?
Well, I would answer that yes, but I wouldn't want to say that it was more so than it was the previous year.
If there were more money, there would be.
That's my point. I was trying to figure out a way to say that politely and nicely, that when you're on a shoestring budget, there's not a lot of flexibility. There's just not. Once you meet all the bare necessities and your revenues are consumed, well, you've met all bare necessities and your revenues are consumed.
Do you see the flexibility coming through the ESEA waiver to be able to maybe provide some relief?
I think that actually is going to be a very beneficial move for all districts. We were probably a little bit ahead of the curve because we were anticipating some of that, hoping that would happen. But yeah, that fits very well with student-based budgeting and concept.
It does, philosophically. Okay.
Yes.
What I'm seeing is all schools are unique, so some schools have more needs than the others. So in the past, if you were giving one position to a particular school, then the other school says, well, I need this position also, but they may not need that position because one school may be more at risk and it needs additional help. And so with the student-based budget, it sort of helps to even this out. So you don't have to do that.
Mr. Lee?
Yeah.
Ms. Ciano, what is the process for taking the lessons learned from the pilot and making it available to all the districts?
Well, what we have included for your review today is a draft of a handbook, and we will continue to work with the districts this summer just to get some final thoughts from them. And then that handbook will be available on the website, as well as, I believe, I'll try to work through the new structure of the department to make sure that the program staff that we were working with the districts know about this opportunity. We've done that in the past with other staff in the department, so that if a district is in a position to perhaps want to do it, or it might be something we would advise that they would look at, we'll have the tools necessary and available for them.
Any other comments by board members? Ms. Beebe.
Well, I do want to commend the superintendents for being the risk takers, and certainly this was a new venture, and certainly being a part of the pilot, you will give us information moving forward. I did hear you, Superintendent Martinez, there were 10 schools in your district involved in the pilot?
Yes, ma'am.
And Superintendent Morton, 4. Okay, moving forward, and I understand because I can relate to the autonomy with the exception of requiring the certification. I mean, that's that's something I will stand hard fast to, but principals have had the autonomy for years to make decisions regarding personnel. But moving forward, if someone wants to be, with regard to the extending the school day, and, you know, that would certainly have an impact on bus routes, have you had discussions about the challenges, or do you see us going to that extent, to where there would be greater autonomy in the way of rearranging the school schedule, making allowances for transportation decisions, and so forth?
And I can't speak for Philip, but extending the school day, I mean, we've got buses that run primary, middle, and high school, so that would almost be impossible. What we could do is possibly have, you know, we'd have to extend it long enough where the buses would come later in the day when they finish running their regular routes to do that. But there's no additional money giving you that to do those sort of things right now.
In your case?
In my case. I don't have any additional money in my case.
Okay. All right. So have you, in your discussions with your principal, and of course I saw I read the supporting documentation, but moving forward with the teacher evaluation and the time involved, have you had any concerns identified regarding the time involved in student-based budgeting decisions and so forth?
What we plan to do with that is, as I said earlier, we realize we're fairly close to student-based budgeting, and we're going to even continue that even with greater fidelity in the future. But I've almost come to the conclusion that the actual book work, we'll continue doing it for the principals. Quite honestly, they don't want to do it. You know, we want to empower them and let them, what truly makes the decision is going to have the importance and the power of what they're doing. But I have 43 schools and have every principal trying to be an accountant track for everything. We've decided that's probably not logistically sound. Although we like the concept and the philosophy, we're probably going to continue to push the pencil for them and track those things for them. Because their time, I want them spent more in the classroom, interacting with faculty and students in the community in positive ways than trying to be accountants, because they're not accountants primarily. That's not what they do, and that's not really a vision I have for them being accountants.
And I totally agree with what he's saying. They haven't spent a lot of time, the accountants. The business department has worked out the figures for them. They know how much money they have. They know how much each person on the staff costs, because a teacher with a master's degree in 30 years costs more than the first-year teacher, and they know all of that. So they're making their decisions based on what monies they have, and the accountants are doing everything else. So I don't see them spending a lot of time, but we will monitor that situation closely.
Thank you.
I too appreciate two successful, experienced superintendents being willing to volunteer to be a part of this pilot, and I think you are seeing some benefits from it. And any other discussion by any other?
I just wanted to recognize, I believe, Mr. Chairman and Superintendent, if it's okay with you, I do believe we also have some staff from Terrebonne Parish who's here as well, who may have been involved in the pilot. I just wanted to recognize them as well. Is that correct, Superintendent?
Yes, sir. Thank you, John.
Of course.
Good.
Thank you all very much for being here.
Good. If there's no further discussion, the chair would ask, is there any objection to the motion to receive? Hearing none, motion carries. Next item.
Your next item is item 4.2 on page 161, a consideration of the MFP accountability report, and the department recommendation is to approve.
Chair would entertain a motion to approve the MFP accountability report.
I'll move.
I'll second.
We have a motion and a second. Any discussion? There's hearing none. Is there any objection to the motion? Motion carries.
Mr. Chairman, I just have a question about how this is disseminated and who actually receives it. This MFP accountability report is a result of a resolution, right? So this this is presented to the legislature, correct? There was some issues and questions around testimony during the last session about, we actually present documentation, but it doesn't always get into the hands of lawmakers. Is there any way to improve on that process or to ensure that it is getting into the hands, that we don't have the kind of conversations that we had in the last session?
We usually send this over to the chairman of the committees as detailed out in the law. We also are required not to send hard copies most of the time because of the rules and the bills that say we should do everything electronically. So we have in the past sent out information to them just about the link where it's posted on our website. We can certainly investigate if
No,
there's
I'm not
anything
suggesting that
else.
we go back to
Okay.
paper copies, I think, but when it's provided to the chairman, do the staff of that committee, are they required to forward that to each member of the committee?
I'm not familiar with how they disseminate it, but we can
That
encourage
seems to
them.
be a disconnect. And also, which committee chairmen receive this? Is it only the money committees?
It's House and Senate Education for sure.
Okay.
I think it's,
Beth, also, is there a way to send an electronic copy rather than just where it's located? I know the volume is a lot, but is there a way to send that so that we can send it to each, if that was?
true, yeah, right. We'll look into that to make sure that there's, minimizes the miscommunication or lack of them receiving the information. We'll look into that.
Okay, thank you.
Did you want to make a comment? Okay, any other discussion? And I think we've already taken action to receive the report.
I believe we did.
Next item.
The next item is 5.1 on page 257, a consideration of federal, state grants and allocations to LEA's Type 2 charters, approved non-public schools, and community-based organizations. The department recommendation is to approve.
I move approval.
I'll second.
We have a motion and a second to approve the recommendation. Any discussion? On the $96.5 million, that doesn't call for much discussion.
What, Mr. Lee, what is the process for the recommendation that's presented here? How is that determined?
Comes through the department? Is that correct?
We actually look at these individual allocations based on the funds available. We verify that these are the methodologies that need to be used for each of the allocations, and then we present them to the board even before, as long as they're recommended for approval, we present them to the board. Otherwise, we would vet everything in the department before recommending approval.
But there are processes associated with each grant that the grant mandates we go through. And some it's a competitive process, and some it's a formula process.
Right.
Yeah. Okay, if there's no discussion, any objection? Motion carries. Next item.
The next item is 5.2 on page 292, consideration of contracts and leases of $50,000 and over. And the department recommendation is to approve.
Okay.
Move approval of contracts, items 1 through 12.
Okay, we have a motion. Is there a second?
I'll second.
Have a motion and a second to approve the contracts that are over $50,000. Any discussion?
Mr. Lee.
Ms. Beebe.
While, and I think Superintendent White, you're aware of the LaSord contract. It's not, as I understand, it expires June 30th, and I'm just asking, why was that not a part of this agenda?
Well, we're deciding whether or not to renew that contract. We haven't finalized the IDEA budget, and we'll certainly keep the board apprised of that. Obviously, if the contract were renewed, we'd bring it back in front of the board. It's not a small consideration, given how expensive it is. It's a $1.5 million contract that affects, I believe, 25 schools. It's a significant investment for a relatively small number of schools. And I think the question that we're wrestling with is, given how expensive it is it something that we should or shouldn't propose to the board that we do? And it's certainly not to say that we haven't, we've said no, it just isn't included today because we just haven't made that recommendation as of yet. Now, I think it's also worth saying that the objective, which is the proper training of teachers of students with autism, couldn't be more important. It's just a question of whether or not, given the limited scope of the program and given how large the investment is, whether or not it's the right way to do it.
Mr. Garber.
Mr. Lee,
Oh,
yes,
wait, I'm
there's a-
sorry. Ms. Beebe, will you finish?
Well, and I certainly advocate the program because we do need more teacher training and the technical support for our teachers, not only special education teachers, but regular education teachers. And that was one of the reasons I chose to pursue the additional certification in special education, is because I wanted to know how to work with children with disabilities assigned to me in the regular setting. I think it's a viable program. It's one that certainly we should give consideration to. And what is of utmost concern is that we have personnel involved. And so my specific question to you, what is the procedure if we move away, if we choose to terminate the contract, or if we choose to extend the contract, what is the turnaround time? We do not meet until August again. What do we do in that lapse of time, during that time lapse?
Well, there are a number of contracts that we would be proposing again in August. You're right that there would be some lapse because this contract ends, but we would be signaling to the group either prior to or thereabouts June 30th as to whether or not we are going to propose to BESE that the contract be extended. We are walking through the IDEA budget so that to make our final plans for next year, and we'll bring the appropriate contracts to BESE at the next meeting. I do want to stress that we don't for a second think that having these teachers go untrained is the right thing. It's not. The thing that we're struggling with is this is a grant that staffs 5 facilitators and then 1 admin person. It covers roughly 25 schools in 9 parishes, but it costs $1.75 million. And we're not condemning the program at all. It's a fantastic program from what everyone says. The question that we have is, could we be doing something on a broader basis than only 9 parishes, only 25 teachers, and only roughly 120 students, for a $1.75 million investment? That's our question. It's complex. It's come to our attention. We're wrestling with it, and we'll bring a recommendation to the board.
And I think Mr. Lee has some experience with the LaSord project in your district. Mr. Lee, do you think it's a viable program?
Well, it works well, very well. But like Superintendent White says, I think they have a responsibility to look at it from a cost-effective standpoint. But it's no doubt they provide good service.
Let me just, if I might just add some background to this. I think that part of the student-based budgeting question, part of the waiver discussion, and part of the kind of overall empowerment question is, to what degree should we be holding our federal monies centrally versus to what degree should we be giving them to districts to do what they think is best for their given circumstances? And so I think that, on some issues like this, it's important that there be central programs that are run, but frankly, our orientation is generally going to be, we think it's best for districts to have the resources so that they can do what's necessary for their kids. And so where we see programs that are expensive, no matter the cause, but that affect a very limited number of our parishes and teachers, we're going to ask difficult questions because to me, the question is, could we take what is $600,000 per year and share it more broadly across people who are closer to kids than to fund one contract that affects a smaller number of teachers? That's really what we're wrestling with here.
And I hate to pit programs against programs or what have you, but I mean, we just approved a program to address 124 students to the tune of $1.1 million. So, I mean, but regardless, the money, IDEA, it's federal. So I think regardless of the funding source, if we're going to use that as an argument that we need to be responsible in our decision-making and the services provided to children, I certainly feel the fact that we're addressing the students' needs, those classified with autism. And beyond that, it's just not the autistic students, but we're helping. It makes a difference even as we have the discussions with teachers of regular students. I think it's a viable program, and hopefully
It is.
Mr. White will give consideration to renewing the contract.
And to be clear, on that, the program that you referenced, we're phasing that program out. So, but it'll be funded, but it's being phased out.
Mr. Garvey.
Yes, as a follow-up on that item, I have a question either for the superintendent or for Ms. Dastu. We have a process in place for some types of contracts to get approved in between BESE meetings. Is this the kind of contract that can be approved in between BESE meetings if we absolutely need it to be approved?
I'm going to defer to Ms. Ciano. Does this meet the parameters of the interim kind of authority, or are we going beyond that time frame that authority was created for?
Well, we have standing approval authority for contracts under $250,000. However, anything beyond that needs the special provision whereby there's a committee set up, and we actually have engaged that committee for contracts of this value, as was in place between the April and the June meeting.
But that expires, correct?
Right, it expires at June 30th.
Okay, so this one wouldn't apply there.
No, we would not be able to approve this under the current authorities existing.
Correct.
But
Until the August meeting.
Next BESE meeting is August?
Is August.
What?
16, 17,
Roughly.
18?
So
Mid-August.
after school starts, but not too far into the year. I'd like to ask a question of Superintendent White. If you decide not to go forward with renewing this contract, could you give the BESE members a written description of how you are going to address the issue of teaching these teachers without the contract?
I'd be happy to. It's probably best done in the context of the overall IDEA budget, however, because I think we really need to ask ourselves, should the State Department be responsible for professional development for a small number of our teachers? And maybe the answer is yes, but by and large, the answer is no. And the reason for that is that our orientation has been to try to put as many resources in the hands of people closer to those students as possible. So I'm happy to do it, but I don't want to commit to the idea that the state should be responsible for training teachers. I think we should be building capacity within districts to either locate groups or to do that themselves.
I understand. But I would appreciate some kind of written explanation of what is going to happen, because there's a lot of parents asking.
Understood, yeah.
If this doesn't get renewed, what's going to happen?
Yeah, we'll do that.
Thank you.
Mr. Chairman, I have a question. Currently, the contract is with an outside entity, correct? Is it LSU
Yes.
that receives this contract? And then they in turn are providing the professional development to teachers?
Yes.
Is that correct? Okay. I would echo what Mr. Garvey said, is that I think I've heard from all 25 schools that benefit from this program, and they're very supportive. So I still would defer to your administrative authority on these kind of decisions and making this recommendation, but communication to the board on this item, I think, is critical.
It will be done.
Let me ask this question. Would you want to consider a motion to grant the emergency authority if the superintendent so recommends?
That excellent idea. Yeah, I'd like to make that motion.
And I second.
Okay.
So you would extend to the existing finance subgroup this authority until the August meeting, is that correct? On just this item or for all, any item?
Well, they would.
The motion is for this item.
They would give the approval, and then it would come back here for.
So it's for this item only, and it would come back to the board in August. Okay.
Okay. Any further discussion on that motion? Any objection?
Mr. Lee, I don't want to beat a dead horse, but once again, moving forward with planning for those individuals involved in the historic project, I don't know the ramifications for them waiting until August to find out whether or not.
This gives authority for the superintendent
So
through this committee.
We'll just ratify it in August, is that what you're saying?
Right, that's correct.
if he brings it forward to committee, you just authorized the finance subcommittee to only act on this one item up until the August meeting, and you would ratify it. But again, there would be communication to the board. Yeah.
Okay, if there's no further.
I do have a question. Mr. Lee?
What's your question? What's your question?
I think Ms. Bofi has a
Pardon me?
Ms. Bofi goes before me.
Okay. Holly?
Thank you. So, this is my understanding. I just want to check. So we are looking at the IDEA budget, and I appreciate you taking a careful look and thinking about impacts of the different programs. And also thinking about districts being in a position to best train their teachers or make decisions about how their teachers are trained. Could the districts create this contract themselves? Could the districts come together and collaboratively to get this kind of work accomplished? Okay. And then how does the IDEA budget, is that limited to just the state doling out the funds, or are those funds that the state can say, you know what, if we're giving you this responsibility, then we can pass money down to you to make good decisions about how to use that money?
Well, by and large, the dollars, there's discretion over who spends those dollars, not entirely, but by and large. And I am going to suggest to the board that we take a position that where there is discretion, that those dollars be in the hands of schools and school districts rather than in central run programs. And, you know, I'll just tell you candidly, our analysis of the federal programs budget at present indicates that we have a pretty large, not large in the aggregate, but percentage-wise number of kind of items that we're spending centrally and then giving to districts rather than taking the dollars and giving them to districts and saying, how would you best spend them? And sometimes that's the right call, but I think probably it merits another look, and that's what this is the result of. So yes, they could do it. I think we should do as much of that as possible.
Okay. Any further discussion?
So,
Any objection to the motion on the floor?
I believe we actually have two motions currently on the floor.
No, we approved that first one, didn't we?
I do not believe we did. So if we
Okay,
could,
okay. If we didn't, then the first motion.
yes,
To
to approve the contract.
Right.
And we have a motion and a second.
And I think we did have discussion on it. Okay, is any objection to that motion? Motion carries. Now, the second motion,
Now, the second motion, as I understand it, is that if the superintendent recommends approval of the Lassard contract, the board,
with the committee's
with
approval.
the committee's approval,
Then it would come.
and the board president, then it will have emergency authority and will come back to the board for ratification in August.
That's
And
correct.
if there is,
That would keep it from terminating if
Correct.
that decision is made.
correct.
Okay. Any further discussion on that? Any objection? Motion carries. Next item.
Item 5.4 is on page 331. It is a consideration of fiscal dialogues as a result of the fiscal risk assessment process, and the department recommendation is to approve.
Okay. Page 331.
So moved.
We have a motion, approval of the fiscal risk assessment process. Is there a
Second.
And a second. Any discussion? Since none of us know what that means, I don't think there can be much discussion.
Mr. Lee, some of us know what it means.
Okay. Any objection? Motion carries. Next item.
The next item is 6.2 on page 355, a consideration of RSD contracts and leases of $50,000 and over, and the department recommendation is to approve.
Chair would entertain a motion. We have a motion, kind of weak,
Second.
and a second. Any discussion? Contracts and leases over $50,000. This is Recovery School District. Any discussion?
So-
Ms. Beebe.
As, I know we have the supporting documentation, and I would assume that this is, the recommendation of Superintendent White, but, and it's just, I guess my question is.
It's here for your discussion and/or approval as
You can ask questions.
recommended by the motion.
Well, these are all approved by, now, under the Recovery School District, they have Superintendent Dobor and Mr. White, you give your blessings to all of that. Is this the procedure? Because although I've been on BESE, about 6
Yes.
months,
Yes,
I
if
want to
it,
understand
when
the
it,
procedure. So Mr. Dobor makes these recommendations?
Mr. Dobart reports to the state superintendent reports to this board.
And
When
Mr.
this
Chairman?
recommendation is made, in effect, it's a recommendation of the state superintendent.
And I would like to add that the board met in the New Orleans, the Recovery School District, and we actually did take action and approve these items. So there's been a layer of a board meeting on these items.
And if I may add to Ms. Dastu's comment, for a period of about 4 to 5 minutes, and it was over, I mean, you know, they were presented, no discussion, and I'm just not accustomed to approving without having explanations offered. And yes, I can read, but, and I see the information presented, and I certainly commend staff. It's not it's not my intent to create any negatives towards staff. It's just, this is a lot of money, and so I'm just assuming to understand the process. Superintendent Dobor reviews it, and then he makes the recommendation to you, Superintendent White, and you in turn, you recommend it to us?
Yes, I mean, there's also a bid process on all of these, that there's, so state laws govern the procurement process that these then are put through. So I think it's fair to say, Ms. Beebe, that the recommendation, the choice of these vendors is not made by any individual, it's made effectively by the law, which stipulates a process that the job effectively goes to the lowest qualified bidder, and then that name is represented here. So Superintendent Dobar and his team and I have obviously, we're bringing this recommendation to you, but only insofar as it's the result of a legally mandated process of which we had no part.
Okay. Thank you for the clarification moving forward.
Thank you.
Although the process, I now have an understanding.
Ms. Beebe, I think you do make a good point in that it is lots of money, just lots of money. And, you know, there's already scrutiny in the media about some of the particularly very large contracts. They're in the area of testing. But I think we do have a responsibility to ask questions, to try to be informed, because we are responsible for the expenditure of a lot of money. Okay, if there's no further discussion, any objection to the motion? There's no objection, motion carries. Next item.
The next item is 6.4 on page 388, a consideration of a review of the 2012-2013 budget for the Recovery School District. Board members, I will point out you do have a color copy that was handed to you at the beginning of this meeting. Oh, and the department recommendation is to receive.
Okay, we have a recommendation to receive. We have a motion, and Mr. Garvey seconds. Any discussion? Any objection?
Only if you let me go back in history and talk about when these budget reviews, how this began, expanded, and now has gotten to what is really, I think, an excellent and understandable kind of presentation.
Right.
I remember the day the RSD budget was on half a piece of paper, and so, and then when it was also 3,000 pieces of paper. So, yeah.
It has come a long way.
It has. I've been around too long.
Okay, if there's no further discussion, is there any objection to the motion to receive? Motion carries. Next item.
The next item is moving on to item 7, the standing items, Louisiana Quality Education Support Fund.
Chair would entertain a motion, preferably to receive items 7.1 through 7.7.
I make that motion in blow, to receive those in blow.
Okay, we have a motion. Is there a second?
I'll second.
Okay, we have
Mr.
a-
Chairman, we really need to commend Kim and her staff for doing such an excellent job. She has really stepped up in this role and has just made us very proud. So, good work.
Okay, we have a motion and a second to approve item 7, items 7.1 through 7.7. Any discussion? Any objection? Motion carries. Next item.
The next item is 8.2 on page 440, consideration of BESE contracts and leases, and the department recommendation is to approve.
We have a recommendation for approval of the BESE contracts.
So moved.
We have a motion. Do we have a second? This item, this group we're contracting with might be somewhat questionable, but we do have a.
Was that a joke?
Okay.
Is there any discussion?
I have a question.
I'll
Maybe-
withdraw
Okay.
my recommendation.
So these, the contract that we just approved or get ready to approve, this is startup money for charter schools? I guess like, if it's a new charter school, BESE has authority to give them X amount of dollars to have funding? Is that correct? That's my.
Yeah, there is funding provided for the loan program. Isn't that correct, Superintendent?
Yes.
And this is giving the department authority to administer it.
Okay, and there's a process where it's the application process, and I'm just trying to get clear understanding, because this is my first time ever understanding.
No, you moved ahead too.
Yes, this is a loan fund that is available to student Texas charter schools. There is a process for which to apply. They actually have to pay the loan back, so it's an interest-free loan. And this is lived in our office because that's we use to run all of the charter school stuff. And we are transferring this money over to the department so that they are the ones
Page
who
440.
high school for which this is helpful and can actually help them apply and administer the loan. So this is simply a memorandum of agreement between BESE and the department to transfer these funds.
Okay, is that, any further discussion?
Mr. Lee, I'm sorry.
Ms. Beebe?
I didn't hear Ms. Peel's question clearly, and I did get a bit of Ms. Posanak's response. So, did you ask this money as it's, reported here, 436,000, that's for startup money for charter schools?
That's right. That's the fund that's available for startup costs, a loan fund.
And that's to those operators, the entities that would want to establish a charter school, we would give them 200, what was that dollar figure? Is it 200,000?
It was up to 100,000, I believe.
It's a loan. It's a startup loan that's been in the BESE budget for years and years.
Well, what I'm saying, this is not a significant dollar amount when we're talking about 100 to 200,000 for charter operators. Am I?
You are correct. I mean, it is not a significant amount, but when you're starting up a school and it's potentially an interest-free, or it is an interest-free loan, we are starting to see that there has been more interest in it, particularly as there have been other federal grants that have run out. And so this money has actually been sitting there for quite a few years. This was actually the first year that we had a school apply and successfully apply to receive one of these loans.
But there is a limit to the dollar amount.
Yes, ma'am.
And it's interest-free? You didn't say?
It's,
Yes.
It's up to $100,000, is that correct?
And, yes, what is the payback? I mean, do you have a time? Is it 3?
Yes, they have, I believe that it's in the agreement that they have 3 years to pay back the money in installments.
Are we prohibited from earning interest?
No, the loan actually does earn interest, whether that's swept, that interest is swept or not is at the discretion of the state.
But technically, if I want to open a charter school and I borrow $100,000,
Oh, right.
am I paying back $100,000?
No, it's for, that money is actually used to reimburse expenses. So they can't take the $100,000, put it in a bank account, and to earn interest on that money.
She means the payback.
I mean payback.
Is there interest accrued on the payback?
Repayment.
Ms. Beebe, Pete LaFleur with BESE. The statute states that the interest, the loan is interest-free, and it was set up that way. That's what the statute's written. So it's, we can't pay, we can't charge interest. And it's to, as Ms. Posniak said, is to get these charter schools started.
Okay, further discussion? Any objection to the motion on the floor? Motion carries. Next item.
Your next item is 8.3 on page 448, a consideration of BESE property, and the staff recommendation is to approve.
This is approving cooperative endeavor agreements with two school systems, Washita and Sabine Parish, and Chair would entertain a motion to approve both.
Second.
I have a motion and a second. These are properties that's owned by BESE, but operated by those school systems and have been for a long time. They're schools, individual school sites, small sites. Any further discussion?
Just additional clarification, Mr. Lee. So these are properties in Washita and West?
In Sabine Parish.
In Sabine. And so what are we asking for here? The recommendation is to approve what amounts to a contract. It's a cooperative endeavor agreement with those school systems where they operate those facilities. So they lease from us the building? Is that what you're saying?
From BESE.
And we're asking for the approval of the lease?
Okay, any further discussion? Any objection? Motion carries. Next item.
The next item is 9.1 on page 459, a consideration of revisions to the Louisiana Administrative Code, Title 28, Part 1, also known as the BESE Code. The staff recommendation is to approve as a notice of intent.
So moved.
Okay, we have a motion and a second to approve the revisions to the administrative code.
Mr. Chairman, this
Somebody want to review with us what the amendments are?
Sure.
This is good.
So this is...
Briefly.
Sure. You don't have to tell me twice. And so these are a series of revisions to BESE's internal policies and code that we use. And it was last promulgated and put through to rule in 2008. And what our staff has discovered over the last year or so is that there are a number of things that are outdated throughout the code. So references to different laws that have changed, perhaps references to previous configurations of the BESE districts that changed last year with redistricting. There is a large section, for instance, taken out on the RSD because at the time that this code was put together, there were not laws that were guiding on the RSD, and actually there are now, so we should remove them from our code because statute overrides this policy. So we wanted to make sure that there wasn't any conflict that existed there. Also, there are several changes that respond to legislation regarding the special schools that came through in this last session.
Are there any changes to the policy?
No, and we very intentionally chose not to do anything that was not alignment, technical changes to this code. So there's nothing that changes that has not been prompted by some other event or law.
Okay, any discussion?
Yeah, I'd just like to commend all of our staff. I can see several members' handiwork in this while reading it, and it's really, this is an arduous task, and I commend the executive director and our BESE staff for taking this on and cleaning this up.
I would also just want to acknowledge Nina for the board recorder who has collected all of these necessary changes for the last few months and actually put together the final copy of the revisions.
Any further discussion? Any objection? Motion carries. Next item.
The next item is 9.2 on page 472, consideration of revisions to Bulletin 921, the Policy and Procedure Manual for the Louisiana Quality Education Support Fund, 8G. The staff recommendation is to approve as a notice of intent.
I mean, I went over.
Okay.
Is this the same thing?
Well, actually, this bulletin has never been promulgated. So it was put together, but we actually didn't do it as a notice of intent. So we are going to go ahead and put that through the process this time.
Okay. But again, it's putting in policy our operation, our practice.
Yes, sir.
Chair would entertain a motion to approve the policy.
Motion.
I have a motion and a second. Any discussion? Any objection? Motion carries. Next item.
That concludes your agenda.
Who's chairing?
We will now be breaking for lunch,
Academic
and
goals.
academic goals will meet at 1:15.
Testing, 1, 2, testing, testing, 1, 2, testing. This is the meeting of the Academic Goals and Instructional Improvement Committee, Monday, June 18th, 2012, in the Louisiana Purchase Room. Mic test. Mic test. These need to be turned up. Mic test. Mic test.
Left click and then drag.
Mic test.
Oh, after the right, after you get rid of the right.
Mic test. Mic test.
And then, yeah, and then you can even hit F11 to get full screen. Not good.
Mic test.
Now we're good to go. Cool.
Mic test. 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 Floor mic 1. Floor mic 2. Floor mic 3. Floor mic 4.
Well, Linda said she can't understand her tape at all. Why has it buzzing?
going to get started now with the Academic Goals and
John,
Instructional
Dennis,
Improvement Committee. Roll call.
That's what I want to do.
Ms. Beebe? Ms. Beebe is present. Mr. Bennett?
Here.
Mr. Bennett is present. Ms. Bofi? Ms. Bofi is absent. Ms. Bradford?
Here.
Ms. Bradford is present. Ms. Destug? Ms. Destug is absent. Mr. Garvey?
Here.
Mr. Garvey is present. Mr. Gio?
Present.
Mr. Gio is present. Ms. Hill? Ms. Hill is absent. Mr. Lee?
Here.
Mr. Lee is present. Ms. Jones? Orange Jones, sorry.
Present.
And Mr. Romer? Mr. Romer is present. And Mr. Nakhan?
Present.
Mr. Nakhan is present. You have a quorum.
First item.
Your consent agenda is ready for approval, adding items 3.1, 5.1, 5.2, 6.1, and 7.3, noting that 7.3 is a notice of intent.
Do you have a motion for approval?
So moved. Second.
Have a motion and a second. Any discussion? Any opposition? Motion approved. Next item.
The next item on your agenda is item 4.1, page 16, consideration of a request for applications process for Louisiana Course Choice Program. The department recommendation is to approve.
We have a motion on the floor. We need a motion on the floor for this item.
So, move to support the department's recommendation.
Move for approval. Any
Second.
second? Thank you, Mr. Gio. Any questions?
Madam Chairman, if I might just make a couple of comments.
Absolutely.
Thank you. This is a new bulletin that will effectively start and manage what is called the course choice process. This comes out of the Act 2 legislation that was passed in this most recent legislative session. And while it wasn't as talked about as some of the other aspects of Act 2, what it essentially allows is for funding to flow out of the formula so that families and students can choose to take courses that may not be provided by the school that the child or the student attends. Such courses are going to come primarily from one of four providers: institutions of higher education, industry and actual corporations themselves, 3 from online providers, and 4 from teachers or other educators themselves. They will develop such courses in response to the request for application, no different from a charter school in that respect. They'll then apply to BESE, but there will be an outside group, as there are with charters, that essentially review and either endorse or don't endorse the proposal previous to the department's recommendation to BESE. BESE would then authorize the course, and the course will be like any other course. It will have a assessment, it will have a scope and sequence, it will have a way of assessing whether or not the course was successful, and those ways will accord with standards that exist in any one of these courses. I think what you will see in response to this is something that is unique across the country. There are elements of this that already exist, like dual enrollment, for example, in higher education. This will expand access to dual enrollment. But I think probably more important, it will yield, new providers of educational services, such as corporations actually doing workplace-based training for students who otherwise wouldn't have access to our K-12 system to grant credits. It will yield an openness to advanced placement and other rigorous coursework that too often doesn't exist in other places. And perhaps most important, it will give teachers a way themselves of developing courses as entrepreneurs and essentially marketing those courses statewide. And we've already talked with a number of teachers about their interest in this. This is under the leadership of several department staff who have done really an amazing job getting this up and running so quick since the legislative session. Ken Bradford, Dave Lefkowith, and Debbie Shum's team has been assisting deeply. So we recommend it for your consideration and are available to answer whatever questions.
Ms. Buffy?
I'd just like to add how excited I am about the opportunities that this is creating for students, and also the opportunities that it's going to create for our educators to be involved in education in different ways. Now that we have the technology to reach students in new and different ways, and that you do not have to be face-to-face in order to instruct kids, we'll give kids an opportunity to be taught by some of our most effective educators this way, and also give educators a different approach to teaching. So I'm thinking about how oftentimes to be a teacher, you're so limited in structure. You have to have a full-time schedule based on the school schedule. This would definitely allow our teachers who might want to work part-time virtually to be able to do so. This is just an incredible opportunity, and I hope that a lot of people pick up on it and that it is one of these options that our students take into consideration.
Any other comments? Mr. Lee?
My question is, how's it going to be financed?
Well, I think one of the things that we've heard from teachers or from corporate entities or what have you is that it's essentially hard to provide these kinds of services to schools because there isn't funding, and it's always supplemental. The MFP attaches funding to these courses at a maximum of 1/6 the appointed MFP for, 1/6 of 90% of the appointed MFP for that semester or year. However, that's a maximum, and as with scholarships, the tuition can be lower than the 1/6 of 90% of the MFP as well. And providers have an incentive to make it lower because we will assume that the parents will be looking for courses that are priced at a lower price point, in part because that might allow you to take more of such courses.
Any other questions or comments?
Just 1 second. I think what Ms. Wilkie said earlier, I think this is...
I'm sorry, Mr. Lee, you weren't finished. I apologize. Mr. Lee?
I'd like to react to his comment. I'm only concerned with that. I'm not opposed to this. I think the concept is good, the idea is good, but I see it putting another burden on local school systems because they're using that MFP money to employ teachers and to employ other personnel. You know, about more than 85% of the money goes for pay. And then local school systems have all other kinds of other expenses. I just see this as another cost to local school systems. And it's just to say they can use 1/6 of the MFP money. That is, you know, local school systems have budgets they have to operate on. And they don't have any way to budget for that.
Well, I don't disagree that if I were running a local school system, I'm not saying I would be happy about not having as much revenue. At the same time, frankly, local school districts are increasing the amount that they are using to purchase online services, to purchase dual enrollment, which they pay for already. You know, it's all one and the same. I mean, it's simply basically paying tuition for a kid to attend school somewhere else.
Ms. Orange Johnson, then
Simply just to follow up with what was said earlier, I just think this could be immensely promising. I just wanted to commend the department for its work. A question about the way that the course, anything would be advertised. Is that primarily through the website of the DOE? Is that how we're thinking about how the actual programs would reach the public?
Well, I think we have an initial stage, which is to work with universities. We hope that our dual enrollment providers will come through this process to work with online providers, industry-based providers, and to market to them this opportunity. But then, you're right, subsequent to that, we need to work directly with schools, guidance counselors, and family members. And that's really the most critical thing of all. We're going to have essentially an online portal through which counselors or families will have access. They will be able to log on, they'll be able to see what courses they're eligible for and to enroll from there. And we're going to do, I believe we're starting meetings across the state already to actually meet with potential providers, to meet with parents, and we'll be doing a kind of grassroots campaign across the state to get the word out to parents about the options that are available to them.
That's great. And just to follow up, do you have any initial sense of what kind of supply already exists? Like just what kind of interest there is on the potential supply side based on initial focus groups you've done? Or
we've been meeting with corporate entities, we've been meeting with universities, we've been meeting with online providers, and we've been meeting with teachers. I think there's going to be varying levels of of interest one way or the other. I think that the online providers will get into the space very quickly, as they already are in the districts. Two, I think the universities, when we're meeting with them, it will take some adjustment because they're already, selling their services to districts already, and we'll be basically saying, let's have a unified process. The teachers, I think, will be the most challenging to market to, and the corporate entities are showing a lot of early support, but they want some sense of, so what's the process? How does this actually going to work? So I think it varies depending on the group, but we're having different conversations, and there's a lot of interest so far.
And I'd like to add that one of the things that will be available.
Oh, I'm sorry. Mr. Garvey, do you yield? Ms. Betty.
One of the things that will be available is that as students pick courses or enroll in courses, is that online the students will be able to track whether or not that'll help them in earning their diploma, and also make sure that they meet all the requirements that exist for TOPS. So since there are various requirements that students have to meet.
Mr. Garvey.
Yeah, question for Superintendent. Have you given any thought to what kind of a timeline there will be for registration, with the thought being that, as Mr. Lee was talking about, the local school system probably will need to know ahead of time, somewhat ahead of time, how many teachers they're going to need for that coming school year. So the more lead time we can give them regarding how many students are signing up for these courses, the better they'll be able to plan. And I don't know the answer, because the more lead time you give them, the less flexibility you give to the students, and you're cutting off some students that are, late minute deciders. But have y'all thought about that?
We want to be as flexible as possible, and so we're on a timeline to basically publish the course catalog January 1 of 2013, which is well before high school students enroll, for that fall semester in terms of what courses they're going to take. And we would, in doing that, allow counselors to actually speak with students, no different from how they already do it, about what courses they're going to take next year. We would hope, because the law would allow for counselors not to discourage students from taking courses, but at the same time, we're not trying to work around the guidance counselors. We think you have to work with the guidance counselors on this as well. So point being, whenever the counselors enroll students, they will already know or will be able to work through with students selecting these courses.
So y'all not thinking about setting up a cutoff date several weeks ahead of the start of school, after which time students can enroll?
I'm sorry. There will be a cutoff date in the enrollment process. Ken, I don't remember what the cutoff date is that we've planned.
We're building the RFA for a course management / registration system. We're going through the state procurement process for that. We will release that. Following that, the course catalog will be published. We will populate that into the system where students can come in. Courses chosen will be able to be mapped back to diploma paths. And then we're scheduling right now for mid-February to early March deployment of the system, where students, counselors, and parents will have access to the registration system.
When would the cutoff be, after which time a student cannot register?
Yeah, so the board is going to be able to determine what the course offerings of when the window of time that a course can be offered. We're looking at it running simultaneously on a calendar like we currently do with our state virtual school, which is courses would go live in the first or second week of August, depending on the provider. And then we would have a cutoff of July 1st where they could enroll, and that would give time for the system to get populated, get the information to the providers for students to take courses.
Thank you.
And this is just, today we're just approving the process. And so it will come back to us, is my understanding, when it's finalized.
That is correct. And what will happen is there will be an RFA crafted. We will solicit for providers. Providers will apply. And then after the process of being vetted, we'll bring back to the board, probably in December, a list of recommended course providers for the board to approve. And then each provider will identify how many courses they would like to offer in what areas, as the superintendent alluded to, whether it's college credit courses, CTE, business industry courses, teacher-led courses. We'll bring that back to the board for approval.
Thank you. Any other questions? I want to commend you all on the work, and on the backup data, it was very good and very easy to understand. Any opposition? If not, so approved. Next item.
Next item is item 5.3 on page 21. Consideration of the appointment of the director for Louisiana School for the Deaf. The recommendation is to approve.
We need a motion.
I so move.
Thank you, Mr. Gibb. We need a second.
I'll second.
Mr. Garvey, any questions?
I would just comment, board members, that Nancy Benham was a name that I first heard a couple of months back when this process was under consideration. I asked to meet with her, as obviously this is an extremely critical position for our state. And having met with her, having heard from Elizabeth Moore her credentials, and then having had her talk to me about her record, not just in education, but as really a leader in deaf education in multiple places across the country, some here in the South and then also in Pennsylvania and others. I was extremely impressed, and that's why we're bringing this recommendation to you today, to bring her on board as the leader of LSD.
Any comments or questions?
Is she here?
She's not here today.
I don't believe she's here.
Would you like to make a comment? Okay. Mr. Lee, anything else? Hearing no further discussion, all those opposed, motion passes. Next item.
Next item is 7.1 on page 30. Consideration of revisions to Bulletin 741, Louisiana Handbook for School Administrators, Section 2907, Connections Process. Department recommendation is to approve as a notice of intent.
We need a motion for this item. Move it to approve as notice of intent.
Ms. Dasty, do you have a second? Ms. Hill, thank you. Any discussion or comments? Hearing none. Any opposition? Motion's approved. Next item.
Next item is 7.2 on page 32, consideration of revisions to Bulletin 741, Louisiana Handbook for School Administrators, Section 2395, Distance Education. The department recommendation is to approve as notice of intent.
Do we have a motion to approve?
So moved.
Thank you, Mr. Garvey. Do we have a second?
I second.
Ms. Hill, thank you. Mr. Reimer?
On page 33, this is distance education. Is this specific to the Louisiana school, virtual school, or is it all virtual schools? Or is it, I'm just trying to clarify.
Mr. Bradford?
Ken Bradford, Louisiana Virtual School. This is a policy that's actually applicable to all LEAs that offer distance learning courses. Currently, what the policy states is that any student who takes an online course, there must be a Louisiana licensed teacher within the classroom while the student works on the course. And what this policy is recommending is that the individual whom is in the classroom is either a Louisiana licensed teacher or a paraprofessional. Just to clarify, the teacher of record in an online course is the actual teacher who is delivering the course online. So this is an individual that would come into the computer lab while the student is working on the course. They would monitor the students. They would work as a liaison. And what it's doing also is it's freeing up that licensed teacher in a school building so that they could be on other duties.
Other questions or comments? All those opposed? Motion carries. Next item.
Next item is item 7.4, page 37. Consideration of revisions to Bulletin 741, Louisiana Handbook for School Administrators, Section 2321, Carnegie Credit for middle school students. Department recommendation is to approve as notice of intent.
Do we have a motion on this item? Thank you, Mr. Reimer. Do a second? Thank you, Mr. Lee. Any questions or comments?
I'm just interested in the intent here.
Superintendent, would you like to speak to that?
In the intent? Mm-hmm. The intent is to essentially authorize new courses as eligible for Carnegie credit, and in particular to essentially make courses available for credit that are unique to students who are visually impaired. These courses specifically are geared toward those students, and obviously Braille 1, Braille 2 would be particularly relevant for that population of students.
We're actually on the next item, Superintendent.
Oh, I'm
That
sorry.
was consent, I apologize.
Oh, I'm sorry.
Good explanation. That was a good explanation. I was looking for.
It was rock solid, I have to say.
Ms. Beeben, would you like to address this?
Oh, okay, sorry. So this is, essentially, this is for middle school students trying to get high school credit. The policy requires that the teacher be certified at the secondary level in the course that is taught, or that the student has passed a credit exam in that subject. And this is a proposal to delete that requirement related to the teacher certification. High school students are able to receive credit if the teacher is not secondary certified, and this just brings that into line with that requirement. We think the principal should be able to determine if the teacher is qualified, especially if the student has done well on the exam. And 8th grade students with secondary certified teachers can score below good and can still receive Carnegie credit. So we think there's basis for making this change.
Thank you.
Any other questions? Hearing none, any opposition? Motion carries. Next item.
Next item is item 7.5 on page 39, consideration of revisions to Bulletin 111, Louisiana School District and State Accountability System, to reflect new policy as a result of the ESEA flexibility request that was approved for implementation by the United States Department of Education. Department recommendation is to approve as a notice of intent.
I need a motion on the item.
So moved.
Mr. Garvey, do I have a second?
A second.
Thank you, Ms. Orange Jones. Any questions or comments? Mr. Garvey?
Question.
Oops, I'm sorry.
Mr. Superintendent, why did you want to say something?
Mr. Garvey, if it's okay with you.
Sure.
Thank you so much.
You're so civil.
It feels like a Jane Austen novel. I wanted just to frame this. I recognize this is a large item and look forward to the discussion of it, especially having discussed it with as many of you as I have. I wanted just to say that there are really two, I think, critical objectives to what you have in front of you. The board essentially moved now, years ago almost, to adopt the Common Core standards. And while that is a shift in a certain respect to the GLEs and to the comprehensive curriculum, it is not at this level a shift in accountability until what you have in front of you has been accomplished. In essence, our current accountability system does not align with the expectations of the Common Core assessments that our students will have to achieve and our teachers will have to achieve in 2 years. So first and foremost, this proposal you have in front of you tries to achieve that. As we raise the standards, it's critical to note that this does not purport to drop schools' scores. Just to give you some examples, in Florida, most recently, the test itself was changed so that the bar for performance at a proficient level was increased. Well, that meant that the students proficient in their literacy exam went from roughly 80% to 23%, I think the number was. This is not an attempt to do that. In New York State, when I was deputy superintendent in New York City, they similarly redefined what it meant to be a high school graduate. And in doing that, all of a sudden our graduation rate dropped. This is not an attempt to do that. We have kept schools steady, and I'm happy to provide the numbers in conversation, because the weighting that we grant particular factors is designed to, in essence, reward schools for where they currently are. If you're a B in our current system, you should expect to be a B in this new system. But at the same time, it says we do need to realign our measures with the Common Core. And just to give you some indications of what that means. It means that in the elementary grades, we're not going to anymore be able to give credit for students who are approaching basic. Why? We should have no expectation on the Common Core assessments that students would get credit for approaching basic. At the high school level, we still have our end of course requirements, but we're proposing to assess students against the ACT. multiple reasons for that, but in part, the ACT is fully Common Core aligned. It aligns our system with the same expectations that this board approved when it approved the Common Core standards being applied to all students. Third, advanced placement is going to be the anchoring vision for excellence in this high school system. Why? Because the levels of advanced placement rigor that are required are indicative of excellence in college and excellence on the Common Core. So we're trying to make that alignment. But third, and this is the thing that I think probably goes most unsaid, Bulletin 111 in its current form is extremely cumbersome, is by no one's fault, has been layered over the years with various provisions that people with the best of intentions have put in. And in the end, it amasses to something that is, I think, very hard to understand. To Scott Norton's credit and Jennifer Craig's credit, and to Jessica Tucker, who has really done a lot of the work on this as well, they have not only tried to make a more ambitious Bulletin 111, but they've tried to really reduce the size of this bulletin so that there are provisions that, frankly, most people don't even know about that were kind of gumming up this bulletin that they have really tried to reduce. And I think we have effectively proposed a Bulletin 111 that is less than half of the size of the Bulletin 111 that would have preceded it. So my kudos to that team for doing that work. I know there's going to be a lot of discussion, look forward to having it, but wanted you to have that context, that we're raising our accountability system toward a bar that this board had already approved. Second, that we're trying to do it in a way that simplifies and clarifies this system. But third, we're not doing it so as to humiliate or drop schools' performance on their letter grades. In fact, on our system, schools should expect to be held steady or perhaps even do better for reasons of the growth element of this measure that I'm happy to describe for you. So thanks very much.
Thanks. And Jessica, I may just ask you to come to the table so that if there are questions, you will be available. And Mr. Garvey, I believe you had a question.
One question that I had is regarding the ACT test and the Explore test and the Plan test. Can you tell me a little bit about the difference between those three tests?
The ACT is a somewhat of a longer assessment, but it's fair to say that they tend to mirror one another in the movement up the scale. We're proposing to test Explore twice. We're proposing to test Plan once in the 10th grade, and then ACT on that in the 11th grade year. The tests align. They're graded somewhat on different scales, but each one of them has a band within which you can say if a student achieves that band, then they are effectively college ready. They each have reading, writing, and math components. There's a writing component on the final ACT that we are not going to be including, however, in this administration. So there is, they align quite well. Schools already use them statewide to inform their instruction and to inform how they expect students to do on the subsequent assessment. But we're not going to be using every component of the ultimate ACT.
Okay. And the follow-up question is how do these tests, as you mentioned, that are designed to test whether a child is prepared for college, how does it apply to a child that's wondering whether he's prepared for a career? Or really a child that's planning to go to the career track instead of college track, or if a school has an unusually large population of children that are going career track as opposed to college track, are they going to be harmed because the children are not shooting for college? Do these tests, discount that kind of a student?
Yeah, and we've certainly heard a lot about that. I think that it depends on what your definition of career track is. If you mean career diploma, would a student who is on the career diploma track do as well as a student who is not on the career diploma track? The answer is no. And why is that? Because a career diploma track student is not required, for example, to take courses beyond Algebra 1, which one has to take in order to do well on the math section of the ACT. However, I think any one of us would argue for our own children that even though we might want them to be successful in a career, the career diploma would probably not be the first option that we would choose for our child. And that if you score an 18 on the ACT, effectively you are eligible to go to college, but you are also eligible to go into the workplace, and that there are not, employers who are banging down the doors for people who cannot score at a level above remediation on the ACT. So what we would say is that what we would hope for our students is that they have a choice as to whether or not to pursue career or college. The course choice presentation that you just heard is very much of an attempt to get real apprentice-based career education in as many education programs as possible. At the same time, we don't think that a student who is headed to career by necessity can't do well on the ACT or shouldn't do well on the ACT. And we think that we need to rehinge our entire state's expectations that every child should be able to do a level that is better than remediation on the ACT. We respect the fact that students currently who are in high school who have been slotted for the career diploma may not do well. Given that that's not something that, in our speaking with people, that they would be overjoyed if their student could only achieve the career diploma, we think we should still hinge our expectations to a higher standard. We should hope that kids have a choice of career or college, and that we should realize that it is us as a school system, not some external phenomenon, that placed that student on the career diploma in the first place. We had that student for 9 or 11 years educated in our school system before they got placed on the career diploma, and thus we think this is a reasonable expectation.
Well, a related question is, if a child is not planning to go to college but is planning to go to a career tech, well, he's not planning to go to a 4-year college but is planning to go to a career tech college, what is his motivation to do well on this test?
Well, schools are always, you could say that about it.
And the typical thought is that if he's going into career tech college, he doesn't need an ACT score to get in.
Yeah. Well, you could say that about many different tests. What is a student's motivation to do anything better than a D on a course test? A school is also, or a district is also free to put the ACT into their own grading policies if they want that kind of accountability for doing well at the local level. But we think in the end, good schools motivate kids to do well. And getting an 18 or above on the ACT keeps your options open one way or the other. If you do need to go into a technical or community program that does require the ACT, whether it's right then or whether it's down the line when you're a little bit older, it will not be an unhelpful thing to have had taken that test. We recognize there are students that, a small number of students who might not be motivated, although we think schools have a hand in that. We also recognize that not every student is headed to college, and you wouldn't even want that. It's a 2.5-hour test. We think that the price for sitting through a 2.5-hour test for that small number of kids who aren't necessarily headed to college is completely worth the benefits of rehinging our system's expectations around a college expectation.
Madam Chairman, I just want to ask one question following on that. The TOPS Tech Award has an ACT minimum requirement.
Yes.
Does it not?
Yes.
So a student who's planning, even if not immediate, who's planning on attending a technical or 2-year school could actually benefit from scoring a 17 or above by basically earning a TOPS Tech Award. Is that correct?
That's right.
So why would those students not be why would they not have an incentive to do well on that test?
I don't. It's a good point. The TOPS creates a kind of incentive. I think there are some students for whom a TOPS award of any kind is not, necessarily in their future. I just am one to think, and our certain proposal reflects that we shouldn't take that option off the table for any child at any point.
How do they know? How do they know that that's not an option for them? Who takes it off the table?
Well, if a student, whether, and people will say that it's a parent who decides, and sometimes it is a parent who decides. Sometimes it's a counselor helping a parent to decide whether the student is 13 or whether the student is 15. At certain points, there is that decision to leave the basic or the Core 4 track and get into the career diploma track. We just think that this should always be on the table.
And that's what I would say the value of the plan and explore test are, in that they don't leave that decision in the hands of just maybe someone at the school who has this predetermined idea that because of the student, the way they look, the way they act, or what their address is, that they're not college material. But in fact, as early as 9th grade, with taking these tests, they are given a range of what they can expect to earn on the explore test, and then or his explore plan, and then the ACT. So that is the value in having all three, the whole series of assessments, is that a student and family and child could see for themselves that they have the potential to do something perhaps some adults in a school don't think that they can.
And just to back that up, in Illinois, and by the way, there are 9 other states that already test roughly half the states in the country are ACT test states. 9 of those states fully test every student already. In those states that have moved toward every student being tested who doesn't have a severe impairment, the ACT average has gone up eventually. And in fact, in Illinois, more than 15% of students who reported that they wouldn't have gone to college took the ACT and then actually ended up going to college as a way of background.
Ms. Bradford?
Yes, Mr. Chair.
I would commend the department. This is a lot of quality work in a short period of time, and it's obviously it's moved pretty fast, and the locals are certainly looking in and trying to understand the new system that's coming, and looking forward to getting a system that's settled that we can stick with for a while. To probe that question a little bit further, and the dialogue so far has helped me understand a little better the reasoning behind it. I understand there are some federal requirements to have standardized tests. I'd like to understand that a little bit better. And I want to probe the Law 2 students and have some dialogue on that, of them taking the ACT and what influence that potentially has on the school performance scores. And what do you think? I mean, what has been the historical with that level of student taking this you expect the results to be? Because on the surface it would appear that there's not a lot, well, it's going to be interesting to see what the value is of that.
I think we would probably all agree that students who are severely impaired, whether they are currently Law 1 or whether they are currently classified as Law 2, if they are truly severely impaired, are probably not mentally impaired, are probably not well served by taking the ACT. And as it happens, there are some students who, because of Louisiana's interpretation of the what's called the 1% versus the 2% definitions, there are some students who have low incidence mental or cognitive disabilities that are Law 2, meaning that they essentially would take the standard assessment in a situation where the federal government has said that the Law 2 distinction needs to go away. So let's take that a step back. The reason the Law 2 distinction is going away is because of the federal government's desire to push for equity across states in terms of access to college preparatory and achievement type tests. We are in a small minority of states that have a Law 2. Most states do not categorize students as alternate assessment above the 1%. So the federal government has said that's going away. So if you do that, then the question is, well, what protections for what students are being lost? And I have to say, when you look at the data for Law 2, it's very uneven. We have one district that I believe 0.2% of their students are classified as Law 2. That's Lafourche Parish. We have other districts that are closer to 5% of students who are classified as Law 2. And in part, that's just because of the inconsistency of the standard, but in part it's because it covers such a wide range of students. I mean, quite literally, as anyone knows who has worked with these regulations, there are students who have traumatic brain injury that are part of this category, and there are students who have a reading disability who are part of this category. So we're talking about a very wide range of students. What we have said in light of the fact that this is going away is that we probably share with the board the idea that we would not want to test, for example, students who truly have a traumatic brain injury on the ACT, that we are working to redefine and will bring to the board how Law 1 actually is defined so that we have an appropriate set of students with low incidence cognitive disabilities in the Law 1 category, so that we truly are serving the right purpose, which is equity of access for all, never saying that just because a child is disabled, that means that child can't have access to college level tests. But on the other hand, not making any very vulnerable students subject to an experience that is going to serve no one any good. We have no choice about the Law 2 question. It is going away by federal law. Thus, moving the Law 1 definition to be the right definition is our next charge. And that, I think, is the solution to, Mr. Grillo, the scenario that you've raised.
Other questions?
I have a question.
And then
I
Ms. Beebe, after Mr.
don't know, is it my turn?
Yes, it's your turn.
All right,
Thank you, Mr. Ramos.
In regard to the bonus points, how did we conclude, how I want to say this really, if you look on page, I guess it's 42, so for those that want to follow, item 4D1B, 4D1B. A minimum of 35% of the students in the non-proficient subgroup meet or exceed the expected growth as determined by the value-added model for students in grades K-8 as determined by the ACT series. All right, and then you follow down to item 3 under there, 4D3. Apparently, if they meet 4D1B, they can earn up to 10 bonus points. Is that correct? And I'm getting into the weeds just a little bit. I'm trying to make sure I understand.
That's correct. They can earn a maximum of that number of bonus points, yes.
Okay. And is that where is the 10 added? Is it added, again, I'm in the weeds a little bit, but I'm just trying to make sure. Is it added to the final score?
Yes.
Okay, so that's mathematically how it works.
Yes.
Okay. And how do we conclude that 35%, I know it's random, so I'm going to grant you that. Is that number significant enough to statistically to reward that bonus? I mean, apparently you believe that it is. I'd like to hear you articulate it. Now, I'm going to back up. Make sure I understand another concept before you answer. We've really gotten rid of some of what I call the soft components of the score, and you've structured this much more toward outcomes, which makes it a stronger score in general. I agree with that, and I want to make sure I'm following that properly. And so, if that's true, then I'm willing to look at the bonus, because prior to your term, we had this pretty significant debate on the issue of a bonus. But given that now it seems as if, again, we're going to more actual outcomes on relevant testing data, that a bonus could be, in effect, a good thing to incentivize schools to serve these kids. Explain to me, if it's possible, why this is the right percent. Is that a fair question?
If I say it's unfair, do I have to answer?
No.
The revised document was passed out a moment ago. It's actually going to be 30 now as opposed to 35.
It makes my question even more relevant.
Right. Please be sure you're referring to the revised document that was passed out.
I think I mean, as you allude to, all of these indexes are essentially questions of how do you create the right distribution of scores that motivates people to do specific things. So it's not, something, sort of some natural phenomenon. The 30% was changed from 35, number one, because the feds somewhat made us change our methodology, and that created some differences in the outcome. But essentially what we've done is to say that you get your SPS score as you would normally. At the same time, within schools that are, say, D schools, there's actually really significant difference. And there are D schools that are taking students who are coming to them all below basic, or almost all, and are moving them to a D level. Then there are students who are then there are schools that have kids who by all means should be at a B, or C, and they are ending up a D. So we think that in order to continue to create a certain situation where schools have incentives to take those kids, given that we've ratcheted up the accountability and the consequences in the system, scholarships, et cetera, we think that in order to create incentives for kids to come, you do want to give a real acknowledgement. And so there are several ways of doing that we do that in here. So the question is, to whom do you want to give that acknowledgement? And we started from the idea that let's first look at the distribution. And if you look at the distribution, what you see is that there is not surprisingly, a large middle of schools that basically are not really exceeding expectations with their low performers, with more than 20 or 25% of their low performers. There are a small number of schools that aren't moving anything more than 10% of their low performers. And then there's roughly 20 to 25% of schools that are at that 30% mark and above. And we looked at it then year over year, and what you see is that pretty consistently that set of schools is pretty similar year over year. That there are a set of schools that are, as you might call, the kind of elite in terms of moving low performers. Now, to be clear, some of those are A schools, some of those are F schools. Now, they're not going to be F schools for long, or maybe they're not even F schools this year, but they're every year they seem to be moving up. And so this was an attempt to say, okay, at what point do you cut it off and you say this is the percentage of kids required to be meeting or exceeding the target that would constitute you as kind of one of those elite schools, and 30% was the demarcating line. So then the question is, how do you award points in a way that's clear and in a way that's transparent? And we said you could do it actually quite simply. 0.1 SPS points for every percentage of child that exceeds their expectations. So if you get 30%, then you get 3 points, 3 SPS points. 40%, 4 SPS points. That has turned out to be a methodology that in our discussions with teachers, people can understand. It takes a little while, but people understand it. And second, it gives enough of a bump that it helps people's grades, but it doesn't inflate the core idea of what we have here, which is that a C still indicates something about your school, a D still indicates, a B still indicates something about your school. So it gives enough, whereas people feel like, okay, I see the light at the end of the tunnel, but not so much as to dilute the value of the letter grade. And thus we've landed in this place.
So, if I can follow up, so you're telling me the up to 10 points is based on the percentage that they move beyond the expected growth, correct? So
is based on the percentage of kids who move beyond.
So literally 30% would be 3 points?
30% would be 3 points in math, then another 30% in ELA would be another 3 points.
Okay.
And what you couldn't top out as, let's say you had 50% of kids in math and 50% of kids in ELA. That would be the most that you could get. If a school had 75 points, for example, they could not exceed that.
Theoretically, you would hope that a school that is achieving that would eventually move a letter grade up anyway.
Well, that's what we're seeing, is that this is why I say it's the light at the end of the tunnel phenomenon. And just to put this in perspective, not to go back to the Big Apple, but in a previous school system where I worked, our system was 2/3 based progress. And I think it's fair to say that every year the accountability results felt a little bit like you didn't quite know what you were getting sometimes, because it's true that you had a progress-based measure of a low-performing school, so you could have a low-performing school that was an A or a B. Conversely, our current system is ratcheting up the consequences for low performance, but it's not really giving a light at the end of the tunnel for some of these schools. I mean, just to give you an example, Clark High School in New Orleans, which was taken over by one of our charter groups last year, that had an SPS of 20. It's a long way from 20 to 75. And that's only a D. So, a light at the end of the tunnel is a helpful thing to give morale boost, to continue to attract high-performing teachers, to sort of show that, you're going to get a faster rate of improvement toward that D if you just really put your pedal to the metal.
Is it possible for a school to receive the bonus but not achieve its overall school performance growth target? Does that make sense? It's a mathematical.
It is, I think, possible maybe, but very highly unlikely.
Could you identify yourself?
Yes, Jessica Bagian, or Tucker. The growth goals that existed previously, which were scaled against the 100% proficiency in 2014 and vary depending on where the school was, those are going away. And all we're saying to schools is that if you're an A, we'd like you to grow 5 points. I'll explain this in a second. A, 5 points, B through F, 10 points. And the only reason we're asking them to hit that mark is so that they can be labeled a reward school and hopefully get financial rewards and public recognition that they deserve. They could get to that 5 points as an A or 10 points as a B through F, either through overall SPS growth, through the bonus, or through some combination thereof. So it's not So they could get to the growth goal without the bonus could help them get there. They're sort of separate in that way.
But ostensibly, a school could, if their goal is 10, they could ostensibly get the ELA bonus of 3, but they only moved their low performers that year and didn't really move their higher performers, so they didn't hit their target of 10. I think that's unlikely. I don't know if we've run that report. Relatively unlikely, but possible.
Okay, I'm going to go to Ms. Beebe now, Mr. Bromer.
I've been cut off again.
Yes, you have.
So
We will let you have another turn
Thank you.
if we get to you. Ms. Beebe.
Excuse me, actually, I wanted clarification on the bonus point, which Superintendent White did an excellent job of clarifying that. And I'll yield to Ms. Bofi and then moving along.
Okay, thank you,
I don't
Ms.
know.
Beebe. Ms. Bofi?
So I appreciate that explanation, John. The question here is, and I think this is probably exactly what you've been talking about, is that what are we doing to make sure that our schools are not pushing kids out? Because unfortunately, when you create an accountability system, then people start looking at the accountability system and figuring out what they have to do to be successful with the system. And as much as I would like to believe that pushing kids out of school doesn't exist, it does. And so I think that it probably relates, that the answer will probably relate to what you just referred to in the fact that when you have students with high needs, because those are the ones who ultimately are the ones that are pushed out, that the bonus would be an incentive to do that. And I appreciate any kind of thought that we could put around to making sure that our children are all given great opportunities to be successful in our schools.
Yeah, I mean, just to highlight a couple of things here. Number one, the fact that there's a middle school dropout component of this is significant, and most states don't have that. I think it's helpful. We have changed it so that it's not only a middle school dropout in the proposal, but it's actually a do your students get to high school, and when they get to high school, do they accumulate credits in their 9th grade year, to provide an incentive for middle schools to not just make sure the kid gets to 9th grade, but to make sure that they actually get Carnegie units or in 8th grade or in 9th grade. Second, every dimension of our high school proposal is a cohort-based system, where if you are not in the cohort, there's a 0. So whether it's our testing elements or whether it's our graduation elements, by making the cohort graduation rate, for example, count on its own as part of the accountability system, you're strengthening the idea that a student who's not there, no matter where they went, is a 0 if they're still in the cohort. I think finally, other than that, it's just about tracking schools' retention. In New Orleans, for example, I'm really proud of the things that have been done around the enrollment process and so on. I do think that the board needs to pay close attention and perhaps revisit the question of alternative school accountability and continue to address that question, because I think that if it's about then students getting pushed to alternative schools irresponsibly, sometimes that's the right call, but if it's about doing it irresponsibly, there are ways of factoring the accountability in so that there isn't so much incentive to do that also, and I think we need to address that. That's not addressed in this proposal, but I would hope that we will have that discussion.
Ms. Hill?
Yes, I have a question, Superintendent White. I guess it's coming from my social worker hat now. I know you said that with the ACT component, that all the students will be required to take the ACT test, even those special education students, correct? So what are we doing to make sure, because as a social worker going to the schools, you have many students that have IEP plans, have 504, which they need accommodations due to their ability of academically, they're not quite there. So what are we doing to make sure that those students are going to be properly prepared to take a test like the ACT when they're already struggling trying to pass the LEAP or the ILEAP testing? So, and because the reason why I asked that question is because that score is going to be factored into that school overall score. And so if you have a school, let's just take, for example, a school in my district, I'm just going to hypothetically just say, if we take a school like Ostroma, we know the population that we're dealing with versus a school like Woodlawn. So I'm just trying to make sure that what are we doing for those students who have those special education needs, especially mental health problems, because you have many students that are diagnosed with mental health issues that way beyond this scope of as far as education. So what are we going to do to assure that the schools are prepared for those students to make sure? That's my question.
Well, I'm not sure that there's anything that is any different from what we already would be doing with in terms of educating those students. I think, and for those who are coming to the event this evening, we'll talk a fair amount about our network support model, which I'm very excited about, where we actually will be working through with districts where are their achievement gaps and what are we doing in those schools and areas to prepare students for the Common Core. But I do want to stress that, without being too crass about it, the bus has somewhat left the station on the question of high standards, that the ACT is going to be no more difficult than our end-of-course assessments will be in English and in math and in social studies and science. So at the high school level, those standards are being adopted, those tests are being developed. There will be accommodations made for students on the ACT or on the end-of-course tests who have specific disabilities, and I do think that's an important piece. If your IEP recommends it and it's applicable for the ACT or the EOCs, then you will receive modifications to make that test a more feasible test for you to take in the first place. But I don't think the ACT is particularly different from our end-of-course tests in terms of its level of rigor.
Mr. Garvey.
Yes, I apologize if you addressed this already. Please let me know. But aren't there extra points that a school can get for graduating fifth-year seniors?
There are. In our graduation index, we are weighting points for students who achieve a GED. Obviously not nearly what we would want, but we're weighting it. We are weighting a four-year graduation student. Above that, we are weighting a graduation for students who has attended and passed an end-of-course test, who has sat for an AP test, for dual enrollment, who has passed AP, or has achieved an industry-based certificate. And the highest level is for a four-year graduate who has passed an advanced placement or an IB test. But within that is points for a fifth-year grad. We know that students with IEPs and sometimes students who are just overaged graduate in 5 years. We don't think that's optimal, but we think it's important to be rewarded. So 75 points is what a fifth-year graduate is awarded in this system, which is roughly the equivalent of a low C.
Ms. Bryant?
Yes.
Another area, just to discuss some, so to make sure I understand, and I'm certainly a proponent of advanced placement classes and going to the bonus points. We have 150 for AP classes. I think the dual enrollment is 110. And we've got some significant dual enrollment programs in the state right now. In fact, the policies of this board really encourage dual enrollment. I've heard some discussion around the difficulty of some of those classes, but at the same time, I'm aware of Ole Miss, LSU, University of Arkansas, Louisiana Tech, all accepting those credits from the current dual enrollment classes in the state. So where I'm headed is, how did you come about that it'd be 110 for a dual enrollment and 150 for an AP class? Why wouldn't that gap be closed some?
Sure. Well, again, the weights are indicative of essentially an attempt to honor where schools are performing now. So, in other words, if every student who passed a dual enrollment course graduated in 4 years and was awarded a 110 that is doing that today, schools would be where they are. So in essence, the weighting 110 versus 150 is just a reflection of an attempt to adjust a new model to today's performance levels among students. But you're right that there's obviously a discrepancy in terms of the signal that we're sending to our schools when we weight advanced placement so highly. And first of all, unfortunately, the weighting of a 150 for the AP is probably more significant than the weighting of a 110 for dual enrollment, being high versus low, because so few students do pass an AP. Right now, 5.6% of our graduates, which is only 70%, so roughly 3% of our kids pass an AP. That makes us the last of 50 states in the country. And so on one hand, we know that that's not acceptable. That in part, in a small part, but in part explains why so few of our students persist through college, because you actually see that even students who took dual enrollment don't necessarily persist at a high rate, whereas students that have taken and mastered an advanced placement almost always persist through college. And so it is a fundamentally different thing. Now, I don't think it's different from all dual enrollment programs. I think there are probably some dual enrollment programs that are doing really tremendous work, and obviously I have visited Ruston in your district, Mr. Gio, and have seen the work that goes on at Louisiana Tech. But I do think also, there is some very wide inconsistency. For example, in some schools, you can take the placement test, not pass the placement test, and still get credit for the course. In some courses, there are not placement tests. In some schools, the placement test consists of something that's much less rigorous from another school's placement test. And so what we have said to higher education in this model is that we will weight at 150, and we would urge the board to weight at 150, a student who has passed a test, the level of rigor and uniformity of which is equivalent to an AP. In other words, if Louisiana higher education develops an assessment that is equivalent to the level of rigor of the AP, by all means, we should absolutely award that. But right now, we shouldn't, or unfortunately can't, have faith that every dual enrollment course actually rises to that level. In fact, very few do. And in part, that's part of why when students go on to college, they're not necessarily really doing as well as they should.
Madam Chairman?
Yes, Ms. Destin.
I'd just like to note that we actually, the 150 is for attaining college credit kind of level, right? Success on the test, but actually for taking an AP course and actually, completing a course and actually taking the exam, sitting for the exam, and earning a 1 or 2, which may not be impressive to some, but is an accomplishment for many, is the school is awarded the same points as completing an industry-based certification. So it seems to me that that is pretty well balanced. That we're not saying that AP is more valuable than IBCs. We're saying that extraordinary success on AP is worth more. Am I stating that properly?
Yes, and as it regards dual enrollment, if, for example, if a student takes, Bio 1 at a given Nichols or wherever it is, they could then take the AP Bio test, and if they pass the AP Bio test, then they would get credit here. They don't need to take an AP course. They just need to take and pass the AP test in order to get credit here. And, while I know that there's not perfect alignment between every AP course and every college course, it is, I think, a fair thing to say that there should be a standard level of rigor that the highest points are granted, and that's why we have said an AP test right now is really the only, and the IB, nationally valid college-level attainment assessment.
May I ask one more question? Do you see a day going forward, or a point going forward, where we could actually differentiate between IPCs and dual enrollment, and where there are some that perhaps would be more valuable to the student, or to the marketplace, or to their higher achievement goals within the IBCs? No, within the IBCs. Just like we're differentiating on an achievement basis amongst the APs.
Well, I think that as it regards the IBCs, and we've started doing some digging on this, I think it's probably fair to say that there are some that are more rigorous and some that are more valuable in the workplace than others.
Well, since would that be possible?
I think it is, yes.
Okay.
Yeah.
Ms. Phoebe? Superintendent White, as I listen to the discussion and moving forward with the schools, you more or less predicted that they should continue to perform and not really take a hit from these policy changes. With regard to the GED, I noticed we moved from 90 to a score of 25 points for the GED. To me, that why are we reducing it to that number? It seems like a significant drop when we're talking about the
Yes,
points
now
and the
remember,
number.
it's being scored on a different scale, so that's part of the reason for the drop. But even now, you're right that a 90 in the old scale relative to a 25 on the new scale is a significant drop. The number is designed so as to give schools some incentive once it looks like a student is not going to graduate to get the points, but not to compensate a school in a way that makes it at all desirable for a student to achieve only a GED. And certainly in conversations with schools was our impression that a 90 on the old system out of 200 didn't provide sufficient kind of negative incentive to schools to send a student to a GED rather than to try to remediate them and graduate them. And we wanted to create more distance between the score for a graduate, which at 5 years would be 75, and a GED at 25. Those are significantly different things, and we think that a fifth-year grad should be rewarded much more heavily than a GED.
And I'd like to just respond to what Ms. Hill offered earlier regarding the special ed child or student. You know, as a teacher of special education some years ago, while I always supported or established high expectations, I also realized that I had to set realistic expectations. And this is going to create a paradigm shift for me, and I'm sure many educators throughout Louisiana. But at the end of the day, I hope you're correct in your assessment and that our schools will achieve the success. I just see with these policies, and for example, the ACT, in my research of 1.6 million students taking the ACT, only a fourth of those students met 4 benchmarks. So, I mean, are we establishing realistic expectations for success in our state?
Well, the nationwide average is roughly over 21.1. Our state as a whole is at 20.1, and our state, when you just look at the public school system, is at a 19.5. So at the same time, we've been making a rate of improvement on the ACT that would indicate that, you know, we're actually improving at a faster rate than the national averages. So by that count, you know, I think we should actually do quite well. Do I think that there's going to be a drop at the outset? There very well may be a drop at the outset. There are 25% of our kids currently that do not take the test. But I think 2 things will happen. Number one, I think we will discover that a small number of students, maybe even a fairly large number of students who, had they not taken the test, wouldn't have gone to college, will end up going to college. And second, that it will become part of the culture of our expectations in a way that lifts all boats. And that certainly has happened in Colorado. It certainly has happened in Illinois that have made similar shifts to this. And I would just finally say again that the Common Core is essentially already making this shift for us. The levels of literacy that are required and math on the ACT are beyond where we are now and really more in line with the Common Core.
Thank you.
Any other questions from BESE members?
I'd like to suggest a substitute motion in that we make a cleanup on page 80. And this is the old one. I don't know where it is on the new one because it's not numbered. But it's in chapter 23, section 2301.
What was the page number again?
Page number 80 on the old one.
80.
There's a discrepancy in dates about notifying the board as to when you're going to be closing or reconstituting a school. So based on my conversations with Ms. Tucker, that if we were to strike out the section that says by December 31st of the previous academic year, then we won't have that conflict anymore.
May I just clarify here?
Please.
I apologize for this error. It's my fault. In getting rid of yet another set of plans, which, by the way, we should just call out the long, somewhat scary list of plans that are now being deleted from this bulletin, I copied the date from below into that, and it's an error. What this meant previously was that if a district was planning to close a school, they told us around December, hey, we're thinking about doing this, we're putting together a plan for how it will work. We're not requiring those plans anymore. Of course, we hope that they're doing this with a lot of thought and previous planning, but we don't need that plan, thus we don't need a date, and they can actually tell us toward the end of the year when they've actually actualized on that plan. So.
Is that in the amended, or is it still
No, but we can
incorrect
make
in
that
the
without
amended?
having a substitute motion.
Okay.
We can make that.
We can
motion.
just
okay.
amend that without doing
thank you.
because it's amendment.
Can there be other minor corrections like that, grammatical, without us making a motion to that effect?
Yes, because it's an amended.
I'll saw a couple, I'll come bring it to you. Really, it's a typo, it's not.
I want to make sure it's not a grammatical error, it's a typo.
Okay. Makes me cringe a little bit because I cannot tell you how many times
We're
we've
going to
read this
correct the
document.
typo wherever it is. So,
We have, yes. We have a card from Rain Martin, Stand for Children.
Good afternoon, everyone. My name is Rain Martin. I'm the Executive Director of Stand for Children. And I thought if I came up here and spoke in this capacity as opposed to working at the department, maybe Mr. Lee would not grill me as much as he typically did when I worked at the department. And he's on the phone, so it's perfect timing. We're here actually in support of this particular changes to Bulletin 111. Stand for Children's mission is that every single child, regardless of their background, their income, their racial background, has access to a great education. And we find that these changes in this accountability system really supports that belief system. We've been engaging with parents around the state, and we find that parents have really high expectations for their kids, and they actually have been expressing that they wish the system itself had higher expectations. We think there are three things in particular that really make this strong and that we think are going to really actually mobilize better academic outcomes for kids. One is the changes to the point system itself. It's much clearer. It's easier for parents to understand how a 100-point system with bonus points can match up to letter grades, and that's really important for parents who want to truly understand how their schools are doing and also get engaged around changes that they'd like to see in those schools that they don't think are truly servicing their kids as well as they should be. There's also a lot of things in here around higher expectations. The ACT provision we think is really important. We're also excited that there's no longer points given for kids that are below basic in this new system. I think Louisiana is a good test case for how raising expectations can raise academic achievement. Since 1999, for instance, the school performance score itself has raised about 40 points, and we think that's in large measure due to the fact that there is an accountability system where the increase in expectations have played out more and more over time. Also, it's also achieved a lot in terms of more closing an achievement gap, which we also think is really important. There's still a large number of kids right now who are in certain communities that are behind. We know that the changes in the accountability system previously has decreased that, and we think that these changes are also going to do that. In particular around the incentive and bonus points. We think that's a really creative use of the accountability system. There's a number of kids now who consistently stay behind, and the system is not truly really incentivized or rewarded for working with those kids, and we're really excited that those are in here. You know, I've been with Stand for Children now for 5.5 months. We're fairly new in Louisiana, although they've been in existence in the country for 20 years. And we've had a lot of times to engage with parents. And one of the things that I would say has been referenced most often by parents is the fact that they didn't realize the education they were receiving in their school until they went to college. I've heard that at least 3 times, and even as recently as this past Saturday, we had a kickoff event in our Baton Rouge chapter. We had parent leaders who actually came and spoke, and Mr. Brazier himself said, it really wasn't until I got to college that I realized I wasn't getting the education I needed in the K-12 system. So we really hear that a lot. We know that parents, again, have high expectations for their own kids, and we're seeing and we believe when they tell us that they want the system to also have those same high expectations. So we're here to support that. We weren't able to bring any parents with us today because many of them are either sort of detoxing after the kickoff we had this weekend or at work. But we do have some parents who are out there who are really in support of this, and we hope that you'll be able to see some of their faces and hear from them soon. So thank you for your time.
Thank you. Any other comments or questions? If not, any opposition to the revised edition of this motion? So moved. I think we have a motion. Any opposition? Motion passes. Next item.
Next item is item 7.6 on page 101. Consideration of revisions to Bulletin 741, Louisiana Handbook for School Administrators, Section 2324, Credit Recovery. Department recommendation is to approve as notice of intent.
We need a motion on this item.
I'll move approval.
Thank you, Mr. Romer, second by Mrs. Hill. Any discussions or questions? Any comments? Hearing none, any opposition? Motion carries. Next item.
Next item is 7.7 on page 103. Consideration of repealing Bulletin 1196, Louisiana Food and Nutrition Programs, Policies of Operation, and revising Bulletin 741, Louisiana Handbook for School Administrators, Section 2103, School Food Service. Department recommendation is to approve as notice of intent.
So moved.
Thank you, Ms. Dastig. Do we have a second?
Second.
Thank you, Ms. Buffy. Any comments or questions? Ms. Dastig?
I'd just like to note that I challenged Jessica to, for every new bulletin that she brings before the board, that she brings us the repeal of an existing bulletin.
She might
So
be
she owes us
behind.
one more.
I was going to say
Two
she's
more.
still behind then. Any other questions or comments?
She did cut one in half, so we'll give her
Okay.
half credit.
All right. Any questions or comments? Hearing none, any opposition to the motion? Motion carries. Next item.
Next item is item 7.8, page 105. Consideration of the creation of Bulletin 132, Louisiana Course Choice Program. Department recommendation is to approve as notice of intent.
We need a motion on this item.
I'll make that motion.
Thank you, Ms. Buffy. We need a second. Thank you, Mr. Keough. Questions or comments?
And this is the bulletin that describes the process that was alluded to before when we were talking about the RFA.
Thank you for that clarification. Questions or comments?
Well, I just wanted to address page 109, item D, regarding the course choice program, the providers. Would this be course providers like outside of the public setting?
Ms. Fee, let me interrupt you 1 second. You're getting an amended copy right now, so let's be sure we're looking at that one because that's the one we'll be voting on. Superintendent.
No, it can be providers within the public system as well.
But if they're outside entities, my question is, they would then indeed be responsible for the special education services?
Yes.
That was my question.
Thank you, Ms. Buffy. Maybe other questions or comments? Hearing none, any opposition? Motion carries. Next item.
That concludes the agenda.
Do we have a motion to adjourn?
I'd like to make that motion.
I thought we were going to sit here with that one. Thank you. Ms. Hill, you're second. Thank you. We are adjourned.
If you did that, I would. John, I appreciate the dialogue. It gives me some cover.
Yeah, no, I know.